actual chairs and vice chairs arrive. And Councilor Braden, I'm having trouble promoting as a panelist. And then from our advocate partners, are there other folks who are expected, who we should be waiting for or adding from the attendee room?
Good morning, Councilor Wood. No, I think we're all here.
Okay, great. Okay, then I will commence. Is it Carrie or Candace on the?
Good morning, Madam Chair. It's Carrie. We're ready to start when you are.
Okay, thank you so much. Let's dive in. Good morning, everyone. I am excited to welcome you all to a working session on docket number 0397, an ordinance on surveillance oversight and information sharing in the Committee on Government Operations. My name is Michelle Wu, and although I am a sponsor of this ordinance, I am not technically the chair or vice chair of this committee, so I'm just holding their place until they will be able to arrive shortly. I will read the disclosures and formal introduction into the record, and then we can dive in. This matter was sponsored by Councilor Ricardo Arroyo and myself and referred to committee on March 3rd, 2021. It is a refile from last year's docket number 0684, on which this committee held a hearing and working session in 2020 as well, and then a further working session in April of this year. In accordance with Chapter 20 of the Acts of 2021, modifying certain requirements of the open meeting law and relieving public bodies of certain requirements, including the requirement that public bodies conduct our meetings in a public place that is open and physically accessible to the public, the City Council will be conducting this hearing virtually via Zoom. This enables the Council to carry out our responsibilities while adhering to public health accommodations and ensuring public access to deliberations through adequate alternative means. The public may watch this working session via live stream at boston.gov/city-council-tv and on Xfinity 8, RCN 82, and Verizon 964. Written comments may be sent to the committee email at ccc.go@boston.gov. That's ccc.go for government operations at boston.gov, and will be made a part of the record and available to all councilors. This working session is also being recorded. Okay, so before we begin, again, I'm just doing this on behalf of the chairs who have very kindly provided this. Before we begin, I'll provide a brief overview of what this legislation seeks to do. This legislation establishes standards for surveillance oversight and information sharing. The docket requires community involvement when surveillance is used and when the city acquires surveillance technology. The legislation limits information sharing between Boston Public Schools and the Boston Police Department. As initially filed, the legislation required that the mayor establish a surveillance use policy that applies to every city department and that the City Council approve the policy. Based on testimony from a previous hearing and working sessions, there are proposed language changes to the docket, which would change the scope of the surveillance oversight provisions to apply to 6 city departments or entities as follows: the Boston Police Department, Boston Public Schools, Boston Public Health Commission, Boston Housing Authority, Boston Municipal Protection Services, and the Office of Emergency Management. Changes to the definition section and applicability clauses to the surveillance oversight portions, clarifying which departments would be affected, have been added. Also, in order to have gender inclusive language, his/her in section 16-63.3, subsection B4 has been changed to there. Participating today on the administration's behalf are Superintendent Paul Donovan, Chief of the Bureau of Investigative Services from the Police Department, Sam DePina, Director of Operations for Boston Public Schools, Chris Carter, Co-Chair of the Office of New Urban Mechanics, and Chief Information Officer David Elgie's Department of Innovation and Technology. Joining the committee on from community and our partners who have pushed this forward and been leading the way, Cade Crockford from ACLU of Massachusetts, Nora Paul Schultz of Unafraid Educators, Elizabeth Badger, Senior Staff Attorney from the PAIR Project. I don't see Valeria. Valeria, is she here? Okay, not yet, but we anticipate, Sabrina, I see Sabrina. Okay, Sabrina Barroso, lead coordinator of SIM. Liz McIntyre from Greater Boston Legal Services. I don't
think she can make it.
Okay. And Lena Papagiannis from Unafraid Educators as well as some Emiliano and Laura. Welcome. We're happy to have you. Okay. And now I will go to colleagues for brief opening statements, and then we'll hand it over for presentations. Councilor Arroyo, sponsor.
Thank you, Madam Chair. First, I want to thank, you're the chair right now, but you're also a co-sponsor on this. I want to thank you for your work on helping move this along. And I want to thank the advocates who are here and the folks from the administration who are here to engage today. My hope is that we can complete this and move this out of here today. That is my goal. And because that is my goal, that is the extent of my opening statement. So we can jump right into this. Thank you, Madam Chair.
Thank you, Councilor Arroyo. Councilor Flynn.
Thank you, Councilor Wu. I don't necessarily have an opening statement. Just want to thank the advocates for being here, and also the administration team for being here, and also to Superintendent Paul Donovan, who I've worked with in the past, who's an outstanding Boston police officer. So thank you, Councilor Wu, and I'm here to listen.
Thank you. And Councilor Braden is in the attendee room, but try as I might, I can't seem to be able to technologically move her into this room. So Councilor Braden or team, if you are able, let me know if there's something happening on the technical side, but we know that you are here and present as well. Okay, so I am informed by the administration, I believe Chantal has let us know that there's a red line version available. Is that correct?
Yeah, that was sent 2 days ago, and I know Michelle had sent it to the council alongside with the other documents as well.
Okay, let me just make sure. Do any of the advocates have this version?
We do, yes.
Okay, wonderful. So why don't we ask the administration to walk through some of the proposed changes if I think let's start just for 30 seconds at a high level, if there are any major sort of big picture concerns, and then we can dive in and go line by line. So who would like to start on behalf of the administration?
Councilor, I can offer just a couple things that I know that we added in there on the red line version, which I believe you.
Oh, wait, sorry, Chris. Yeah. I'm so sorry to do this. I see that Councilor Braden and Councilor Bach are now here as well, and wanted just to, if you don't mind, Chris, give them both a chance to offer an opening statement. Councilor Braden, are you able to speak? Okay, I think she may have maybe stepped away. So Councilor Bach.
Thanks, Councilor Wu. Just happy to be here. And, as before, and as I think I said in prior hearings and working sessions, very interested in seeing us, get to yes on this and really exercise that civilian oversight over surveillance. Also, enough of a former bureaucratic administrative person that very interested in making sure that we also do make it work kind of for our departments in ways that they can handle. So I'm glad to have them on the call with us here today. So thank you.
Thank you. Chris, please.
Thank you, Councilor. And to follow up with Councilor Bach's sort of comment there, the substantive changes that we were suggesting, at least from neuromechanics, was to include a sort of provision that sort of has us apply to law enforcement entities, which I think, Councilor Wu, you brought up in the start of this call. So that sort of shows up in the beginning portion of this. And again, that was to think about, what are the operational impacts to city departments for maybe more innocuous types of things, whether that's a traffic study or something that Boston Water and Sewer is doing to sort of maintain their infrastructure and have sort of a separate or different process for what that is. Now that sort of secondary process shows up at the very end of this ordinance in the red line there. And the idea was, after some conversations with our community partners here, with Kate and others, to think about, could we create a working group that could actually sort of tackle some of these thorny challenges around surveillance technology, around data governance, and have that done in a way that actually meets the needs of residents, is transparent, but is also about building trust with them, as well as thinking about city operations, city staff, how we think about training for them, as well as thinking about procurement. So the establishment of a working group that would sort of make those recommendations in a time-bound way. And we really look forward to sort of that collaboration going forward. So those are the two sort of substantive things that we've put forth in here. I know there are other things from other departments, from Do It and from police and from Boston Public Schools, but wanted to raise those two things up so that people are aware of them when they see them. Thank you.
Thank you. Anyone else from the administration wish to chime in first on big picture?
Councilor Superintendent Donovan here. The police department also is advocating for a working group to be established. We would support that. We feel there's a need to, work and everyone to understand, the issues there, from the police department's perspective, the impact that, as far as public safety is concerned. There's just things that are going to inhibit our ability if they're not completely understood. And, sometimes, maybe we need to understand some things too, but everyone needs to see the big picture. And, for every action, there's a reaction and a consequence. So that needs to be understood. And hopefully through that working group, everyone can understand that. We can, do what's best for the city on their recommendations. Thank you.
Thank you. Anyone else from the administration? Okay, so I did want to start big picture because I believe that if we can get to consensus on kind of the general concepts, then it's a different matter when we dive into the specific language of how to articulate that according to the best legal vehicles and all of that. So just in terms of that big picture concept of limiting to specific agencies that are more focused on law enforcement or interaction with the public, as well as the working group, do counselors have feedback on that? I'll start in the same order. Councilor Arroyo, any thoughts?
So I have questions more than thoughts. What I will say is I actually did go through a side by side, printed them out, red line versus red line. And I think when we get into the weeds a little bit, I certainly have a lot to say, but I think on the other stuff, I just have questions right now about what they envision this working group to be and whether or not they're expecting that to be sort of a safety valve where they can get rejected by the council, but then get approved by this working group. I'm trying to figure out exactly what the limits of that working group or what the goal of that working group actually is.
Okay, great. So we want to make sure there's some sense of, if there is a working group, guardrails around making sure it's not a loophole to in the larger picture.
Exactly.
Okay, great. Councilor Flynn?
No questions, Councilor.
Thank you. Councilor Braden? And Councilor Bach? Oh,
yes, I'm here.
Hello, Councilor Braden. Sorry about earlier.
No questions. I was late jumping on, so I will just listen and I'll come back if I have more questions. Thank you.
Okay, wonderful. Thank you. Councilor Bach?
Yeah, no, I think probably I've just pulled up the red line, but haven't had a chance to review it yet. So I think working through that would be helpful.
Great. Okay, and then on from advocates, thoughts on the big picture of working group and limitations to specific agencies.
We are comfortable with limiting the ordinance to specific agencies. I had a conversation with Chris and his team about this last month, I think it was, and we discussed the possibility of the advocacy groups and folks in the administration working after we get this ordinance passed to think about what a different kind of oversight and transparency framework might look like for city agencies that are not engaged in the kinds of surveillance that departments that have policing functions engage in. And so, we're comfortable with that. On the other question, I have similar questions to those that it sounds like Councilor Arroyo has about the working group, the function of it. It's really not clear in the red line that we received whether or not the working group is supposed to provide merely an advisory role or has the power to provide advice to the mayor, who would then have the power to override a decision made by the council. So I would just want to make sure that there's clarity in the language on that. But if it's just an advisory body that serves essentially to flesh out disagreements about some of these issues and provide information back to the council and the administration, I don't have any objection to that.
Any other comments from our community leaders and advocates? Good. Okay, Chris?
I just wanted to point out one thing, Counselor. There are 2 working groups that show up in this red line. So just so folks are aware, if you're looking at this for the first time, there's one that shows up called the Surveillance Oversight Working Group that has a connection to the police department there. At the very end of the ordinance, there is the establishment of a broader working group to what Cade was just referencing, sort of the work ahead of us for these other city departments. What is sort of the process that we go through to make sure that there is something there for how they're using data and how they're using technology. So there are 2 separate working groups that are called out here. They have different functions. I think we are lacking maybe imagination on wording, and that makes it more confusing by calling them working groups. But just making sure that people are aware of that, 2 separate things that sort of show up here.
Okay, so I think at this point, it might make sense to dive into the language, and there's already, as I'm scanning through some pieces that get to this question of what exactly the role and authority and limitations are. Michelle Goldberg, is it possible if you might potentially screen share with the red line version and help us scroll down?
No problem. One sec.
Thank you so much.
Madam Chair, can I make a request that if possible to have both of them sort of side by side?
I think both
Rather
of
than
them.
So there's our version that has amendments to it. So for instance, we changed the scope. There's also the one that was submitted to us by the city. And I think it makes sense to go through them side by side so we can see the actual changes. Because in some cases I saw deletions that weren't actually marked. And so it's tricky to try and measure that when the one that they redlined has things that are missing, but some of them have cross throughs, some of them don't, basically strike throughs.
Okay, Michelle, do you feel like you have both of those versions and would be able to put them both up, or do you need one to be sent to you or the other?
I have both. I'll do my technological best to put them up. So.
Thank you. Sorry to put you on the spot. And while we're getting to the language, maybe if we could spend one more big picture second on from the administration, what is the intention in terms of when the council would not be involved and these groups would be potentially overriding? Do you envision this purely as an advisory, the sort of combination of both of these working groups as advisory groups to work through promulgating the specific details of policies that have been approved through the council? Or could you clarify that relationship? Yes, Superintendent.
So from the police department's perspective, would propose that there'd be a working group established. I think it was, 2 appointed by the mayor, 1 appointed by the city council, 1 appointed by the ACLU, and then 1 appointed by the Boston Police Commissioner. And then they'd review the issues and then make recommendations to the mayor. Now, where it goes from there, who has the authority? I mean, that's for someone else other than, the police department to make the decision, but the working group would make the recommendations to the mayor, and then the mayor and the city council would go from there as far as that. The group would not have, authority to, override anything, just make recommendations to the mayor.
And so if we just make it very tangible, let's say the department is looking to acquire some new software or technology, what would the steps be? This group would be engaged beforehand to assess what the policy could be, and then that proposal sent to the mayor for approval to send to the council?
It could happen in that fashion, or if, if the surveillance report, if we follow the ordinance and we submit the surveillance report and that meets the approval of the council, then it's approved. If it's not approved by the council, then it could go to the working group to kind of hash out, the details of, what is the issue? What does the council want changed? What can be changed? What is the police department saying is necessary and why? And then reporting back to the mayor, and then the mayor making his or her decision on what they want to do with it, and then going back to the council and, trying to hash the whole thing out and come to an agreement.
Okay. That's helpful for my understanding, and I had seen in the administration's red line version, there was one major strike through around surveillance use policy, taking out the approved by the city council line, which seemed to me, so there's still questions of, okay, well, once this group has proposed something to the mayor and the mayor then has it, does the council get a final vote on that? Or if the council does not want to approve it, what happens at that point? I think let's work through these versions and see what the differences are. Okay, so Michelle, could you scroll down for us, please? And Councilor Arroyo, especially if you've already gone through this side by side, line by line, it would be great if you can kind of jump in on.
So it starts with the change. So 1663.1, the purpose is the first major change difference. You can see it here. They've added some language. They added the park rangers, but they took out the Boston Public Health Commission. So I'm not sure what the reason for taking out the Boston Public Health Commission was.
Administration folks, could you clarify? Go ahead, go for it, Chris. Just jump in.
Yeah. I honestly don't know why that got removed. So somebody else might be able to speak to that. I think Boston Public Health Commission, if they have a law enforcement entity there, that could certainly fall in here.
We also removed the Boston Municipal Protection Services.
So is there any objection to making sure those two are both put back in along with the park rangers? Okay, great. Councillor Bach?
Madam Chair, I was just going to make, and feel free to overrule me, just a suggestion, because I know the next section is definitions. When we've done this before, it's been very confusing to do definitions before doing the actual provisions because they're referencing the definitions. So you end up having to explain what's coming later for it to make sense. So I was just going to make the friendly suggestion that maybe after purpose, we jump to the next substantive section and kind of deal with definitions as they're relevant, and then and then come back to them. That's just from past experience.
Sure. Why don't I would suggest, because the one thing that jumped out to me most was something within definition. So I think we should scan quickly through, not talk too much about it, and then we can go to that and then understand how the changes in those definitions would actually impact below. But I definitely agree with your point. Thank you. Superintendent?
Yeah, so just on my screen, the version on the left, the version on the right, which version, left or right, are we kind of, is going to be the final document, I guess?
So the version on the left is the one that we received from Chantal on behalf of the administration with your red lines. And then the version on the right includes the changes that had been incorporated over various working sessions that the council was working off of. And so I would consider the version on the right as the sort of standard of where the committee is in this moment. And then we'll work off, make sure we're comparing it and pulling things back.
Okay, well, in our first working group, I suggested for the purpose, at the end of the purpose there, adding while allowing for appropriate use to assist in the charge of improving delivery of services and public safety. I recall, I thought that the working group was in agreement with that. So I would like to have that added into the final document.
Great. Yes, I remember that as well. And I believe everyone was in agreement. So wonderful. I know Michelle Goldberg is our whiz at this, so we'll make sure that we have that in there. Okay, so that's fine for purpose. And then, so both everything on the left will be pulled into what's on the right, including additionally the Public Health Department, Public Health Commission, and the Boston Municipal Protective Services. Okay, so let's just scan again. We'll scan down quickly through definitions. Does the administration want to comment briefly on why you pulled that out of definitions up to the purpose section?
Yeah, a clarifying question, I guess. So in reading that where it sits now in definitions, it looks like maybe that paragraph only applies to the annual surveillance report as opposed to applying to the ordinance as a whole, if it sits in that lower sections of definitions, but would like someone else's interpretation of that.
Used by any city department during the previous year and containing the info. Yeah, I think it's fine to do it so it applies more broadly above in purpose. Does anyone else disagree with broadening it so that we are pulling it out? Although I guess the downside of doing it that way is that if we do end up, the version on the left then restricts the entire ordinance to those departments. And if there are additional provisions that are generated related to the other departments or supplementing it in some way, then we would have to specifically specify that other provisions in the ordinance also apply to those departments, rather than saying broadly this applies to everywhere in the city, but the only departments that need to produce a report are the ones that are listed out there. Does that make sense, Chris? I think that's what the difference is.
It does, but I think there's multiple parts of the ordinance, right? It's not just an annual surveillance report. There's surveillance use policies and other things. So the question is whether they should apply to all departments, or if you're going to carve out on each of those who they apply to.
Okay.
Yeah.
Got it. Okay. So Michelle, could you keep that in our parking lot? And as we go down through, we'll make sure that we get to the understanding where I think we're all on the same page, that broadly we want to be able to start with these departments having certain requirements as laid out here, and then with the potential for broader policies that apply everywhere else as well. Emiliano?
Sorry. Hello, councilors. Good morning. So may I propose maybe doing a new section called applicability, where we can put sections so-and-so apply to these agencies and sections so-and-so apply to all the agencies of the city of Boston, or something similar. I guess that's the best thing to clarify what Chris was mentioning, so that there is no doubt which section applies to which agencies. Thank you.
Thank you, Emiliano. Okay, so applicability. Okay, I'm going to put that on our parking lot too as a potential way to. We have a couple options. Either it goes in purpose, or it goes under definitions with each provision we want to apply it to, or there's a separate section for applicability. But I think this is just a matter of legal language. So let's keep going down through, and then we can come back to this point. Okay, Michelle, could you scroll down through just so we know generally that there have been changes proposed to the definitions, but not spending too much time on them. Okay, let's see. So this strike through of approved by the city council under surveillance use policies felt significant to me. Any quick notes from the administration?
I think we got to go up on the two. So Michelle, just to give you a heads up, the one with all they're not going to sync up perfectly because the one's longer than the other with all the new additions. So you're going to have to just sort of look at, and some things are out of place. There you go. Perfect.
Okay, these, oh, I see. Without their consent versus with consent. Okay, again, I don't want us to, as Councilor Bach said, let's not discuss right now, but the red line version from the administration wants to specify that surveillance only applies without consent. And that, okay, any electronic data captured, recorded, retained, processed, interpreted, or analyzed at the direction of the city. Okay, versus just data that is retained in a way that can be linked back to the data subject. That feels significant as well. And then the surveillance technology part has been slimmed down. Any hardware used to monitor to intent individuals. Okay. All right. So again, hold on that. Let's keep going down. Superintendent, did you want to comment? Oh, you're muted. Oh, sorry. Let me see. Are you able to unmute this way?
Yeah, I'm sorry.
Okay.
So I'm just, if you scroll back up to the definition, the description of data there, I mean, that's, if it can be traced back, so that's, yeah, surveillance data linked back to the data subject. That is basically every piece of information that we take in. I mean, data is information for us. You know, information, we use data, we use information to develop our deployment plans and our investigative strategies on incidents and crimes. Without that, you know, we're operating in the dark. You know, we're going to be taking a big step back here from a deployment and investigative, you know, perspective, just on how we do things. You know, right now, the police department, the city of Boston, you know, we're ahead of the curve as far as, you know, the surge in crime. You know, and I think in part that's largely due to, you know, in certain sections of the city anyways, it's the cameras. The cameras give us a tremendous ability to solve crimes. We're really dependent upon them. And if we lose that ability, you're going to see an increase in crime because we aren't going to be solving crime. There won't be a deterrent to crime in areas where people know that the cameras are there. If they commit a crime, it's likely that they're going to be identified and apprehended.
Okay, I want to make sure we are quickly scanning through. I can see that these are very significant changes to the definitions, which will be have a big impact on the scope of the ordinance as written. But let's hold on this because this is going to be a big discussion. So let's keep going down through and we will make sure to return to the definitions because that at the end will be a very foundational piece. Okay. And just quickly on this surveillance use policy, the strike through about council approval. Does anyone from the administration want to just clarify, is this because something was changed elsewhere or is this referencing the working group, just so we know very quickly?
So I think that was from the police department. It just, you know, historically, you know, we've run everything through the mayor's office and, you know, the police department would like to continue that, to run things through the mayor's office. And then, you know, the mayor and the city council can work things out as they have in the past.
I see. Well, I think the point of the city council working things out is, I mean, the crux of the ordinance really is that there will be city council approval on the policies. And this is what then Chief Gross came to the council several years ago and agreed to. So I think this is really the foundation of the entire ordinance here. Councilor Bach?
Yeah, Councilor Wu, I think that because I ran a search, I think if you get down to so there's the later section, community control over surveillance, 1663.3, and you go down all the way to sorry, these docs. Docs could use page numbers. And then B under surveillance use policy. Basically, the point is there is the reference to the surveillance use policy further down in the document is that
It's doubles. Okay, got it.
No, but it's that it says that it's going to be submitted, the mayor shall submit to the council for its review and approval a proposed surveillance use policy. So it sounds like what's basically happening is it's like, I think what the administration did here was say the use policy kind of like flows up from the departments to the mayor and then comes to us for our approval. So the approval piece isn't gone. I think there is still that question about the working group, but we'll get to that in a bit. But anyways, my point is, I think probably.
Yeah, no, I hear what you're saying. So basically that, we were originally conceiving of a use policy as something that's been sort of codified and approved already, but this language just says that it's what has been basically proposed from the administration, which will require approval later, which then will be called approved policy or something like that, which I think is a little confusing because if it's called policy, but it's not sort of formalized and usable, I think it should be just called a proposed policy, but it probably means fixing it below so that it doesn't require double council approval.
Right. Yes. And down and below, they do call it the proposed surveillance use policy. So yeah, anyways, the point is there's a technical language thing going on.
Yeah. Okay. That makes sense. Okay. So let's keep going down. Okay. And then we have the working group suggested here. Great. Okay. All right. So now we're into the thick of it. And I'm just going to sweep through because, again, I'm not supposed to be chairing this, so I don't want to take over if someone else is on. Who is the Lydia that is on? Counselor.
It's me. I think I don't know, my camera seems to be off. I've been listening, but I feel like I see myself as sideways. Am I sideways on camera?
You are sideways.
I don't know how that happened. I don't know what's going on. Everyone else looks normal. So I'm going to turn my camera off, but I've been listening and I've been following along. So I guess I can do it off camera because it's distracting. Or if you want to continue, it's up to you.
No, you go for it, Madam Chair. We scanned. So basically, I think you were around for most of it. We talked about the purpose. We scanned quickly through the definitions just to understand that there were proposed changes to some of them. There are some big proposed changes to some of the ways that we define surveillance and surveillance data. And now we're at the actual beginning of the ordinance. So I will hand it over to you.
All right. So, no. Thank you. Thank you so much for doing this work. And thank you to the co-sponsors for filing this. I know Councilor Bach's on here. It's been a lot of work. Councilor Bach, you have your hand raised.
My apologies, Councilor Edwards, that was from before. Okay.
So just making sure we are on to this section on the working group, or did you want to go right into the 1663.3?
I think the idea is let's go into 1663.3, and then later on we can hash out, should it be more people, fewer people in the working group, et cetera.
All right. So 1663.3, community control over surveillance in the lineup of the two. Thank you so much, Michelle. There's, let's see, the administration red line, exceptions and exemptions. And on the other, I think the advocates red line, or the suggested, we have applicability. So is there an issue with the applicability doesn't seem to appear in the original version? Is this new language from the advocates? Is the advocates on?
Councilor Edwards, I know I'm not an advocate. I think that my impression, well, first of all, I'd love to just understand, my impression is that the 712 one is sort of where both the advocates and the counselor sponsors got last time. But I also think, just based on our prior conversation, that this applicability is basically it's basically redundant with a section that the administration has up in purpose that we discussed before. And so it's really just a question of where it's sitting in the document. And then there was some back and forth about municipal protection services and BPHC having been removed. But I think we've sort of already done that piece.
Okay. Any other thoughts from folks? Because otherwise we're just going to go into B, exceptions and exemptions, which I think is kind of lines up with A.
I would just chime in that I like it here under applicability because it feel under purpose, we want this to apply citywide as the purpose, and applicability here just feels more specific to what the starting point is, but open to Emiliano, who had originally suggested this as well, or others.
I agree with Councilor Wu.
Okay. All right. So into exceptions and exemptions, the following situations are exemptions. I believe B1 and A1 are the same. I think then we have the capital letter A under 1 stays the same, capital letter B. I'm just making sure it stays the same. Then there's a C and D in the administration version. For the exemptions, the administration adds surveillance data acquired from third parties for the exclusive use of planning and operation of city mobility systems, and the surveillance data acquired by and for the exclusive use of operating, maintaining, and optimizing utilities operated by the Boston Water and Sewer Commission. You can have the administration speak to those two situations, and then we can have the co-sponsors advocates respond to C and D as additions.
I can speak to some of that, Councillor. This was put in an earlier edit where we were trying to think about how to sort of maintain city operations. I think if the applicability section stands here, this might become a moot point, and it will be something that we address sort of in that end working group along with community partners and council.
Okay. To the advocates, co-sponsors, is that fine? It does look like it would be addressed by the purpose and the applicability sections, but any other thoughts or concerns?
Chair Edwards, yeah, we agree that these should not be included. Yeah.
Okay. All right. Moving on to surveillance, number 2. I'm seeing just in the spot response. Thanks, Michelle. I see that the language is pretty much the same for 2, 2A, 2B. Then we get to 2C, manually operated. The words non-wearable is taken out. Handheld and handheld digital cameras. This is excuse me, for those who are watching, this is referring to surveillance technology. It does not include the following devices: software or hardware. And then listed under C is manually operated. What is struck out by the administration is non-wearable handheld digital cameras. And also what is struck out is the words "and manually downloading video" are also struck out. I would start with the administration. What is the concern with having the word non-wearable, and why having manually downloading, and why are they concerns?
I can speak to this, but I'm sure police department might be able to as well. The use case thinking through here was that the department does some educational video work. They've done it around sort of bike lane infrastructure and other things. Non-wearable means putting on a GoPro or something to sort of do some of that work might be problematic. And also a lot of those sort of video cameras, small video cameras like a GoPro or an action cam that they would do that filming with would also sort of link that, probably not manually downloaded, but also to sort of a cloud system, which then you pull that footage off of. So it's a weird use case, but it seemed like those two words would then require a surveillance use policy, possibly for using a GoPro to make educational and training films.
And then the manually downloading?
Again, a number of those systems, again, GoPro or DJI or the like, often sort of upload that footage to a cloud system, which then you download for the edit. So manually downloading it would require that whatever camera they use is required not to be able to do that, which might be problematic because a lot of those systems have that sort of embedded nature in them.
Okay. To the advocates and then the sponsors?
Madam Chair, the problem that we would have with striking these particular words from C is that it would exclude body-worn cameras from the provisions of the ordinance, which is obviously very problematic given the significance of that technology and the degree to which body-worn cameras monitor people.
Both sections or both parts of language deal with body-worn cameras?
Well, the
non-wearable part, I understand.
Yeah. So the manual download, essentially what this exception is trying to accomplish is excluding from the provisions of the ordinance the use of a camcorder, right? Or a digital camera to take pictures of a city event or something like that to put on, the Boston Police Department's website or the Boston Public Schools, using video technology to shoot, promotional materials or educational materials or something. So that's what we were aiming for. We were not aiming to exclude body cameras from the ordinance.
Okay.
Madam Chair?
Yeah.
Okay, I just wanted to say, I think we should find a better way of targeting that distinction, because my instinct is just, if the same piece of equipment, if the question is whether it's got a clip on it or not, and frankly, the question of whether things get manually downloaded or uploaded to the cloud is going to be a technology change, it just isn't going to be a meaningful distinction necessarily for the long term. So I take Kate's point and agree that those things are importantly different, but I think we probably need to find some way other than the distinction of wearability to make that distinction. And I say that not knowing how exactly to do it, but that's just my instinct on this.
Okay. So we do.
May I offer a suggestion on this?
Yeah, go ahead.
So is it then too restrictive if we just specifically say law enforcement, either worn or operated, as the exclusion from this exemption? So if we change the non-wearable to non-law enforcement operated / maybe wearable, I think we're just trying to take GoPros out of here, basically. So is there a situation where body-worn cameras are not in the police department that we are worried about? And if not, then I think we could just specifically say law enforcement operated here, or non-law enforcement operated here, to specify.
I'm okay with that. If you just want to, if the conditions are around law enforcement, so that we're basically the devices that they're using to survey folks and monitor them, but we're not then.
What if, for example, the Boston Public Health Commission in their outreach team at Mass and Cass or somewhere is now thinking about wearing body cameras or something? I guess I would defer to the advocates if there are ways to be more specific about that, or to say that or to put in the other direction and to say we're specifically going to exclude manual operated handheld digital cameras being used for the purpose of educational videos or something like that.
Right. Is there like an educational promotional event type description that would, right, like to make the distinction? Because what we're really thinking about are body cameras that are just running, to Michelle's point, regardless of who's wearing them, that are just sort of running and collecting, sort of ongoing data of potentially identifiable individuals. I think the council is trying to have some say over.
All right. So,
Madam Chair, can I suggest that we try to come up with some language?
All right.
And kind of put this in a parking lot and come back to it at the end of the meeting.
Perfect. Thank you.
You're welcome.
All right. I see DEFGHIJ, or at least up to I. Okay. The next red line is in K. Cameras installed on city property solely for security purposes is the clause, and the word, the administration is struck out solely. To the administration, is there a particular, what is the concern with the word solely?
Again, this language, we're thinking about some of the things like construction on City Hall Plaza right now, which they're doing a time lapse from time to time, sort of to show construction progress. Would this exclude that use or require a surveillance use policy for that type of use? That camera is not installed for security purposes. It is purely installed for sort of either construction monitoring or promotion or awareness or transparency of like a project that's happening on city property. So there might be a better way to word this without removing that word, but thinking about those types of use cases as well.
This is for the exemptions. Well, okay. Go
just
ahead.
a question for the administration, because it wasn't in the version they were looking at. But wouldn't the applicability at the very beginning of this, the A applicability, deal with some of those issues in terms of like the construction company has a time lapse video or something? That's not the Boston Public Health Commission. To my knowledge, that's not the BHA or the BPD or the Office of Emergency Management, right? Like, so that would, because we added that applicability section, that A, I don't think we have to worry so much about the solely. In fact, I guess my question is, we're over here putting ourselves in knots for C, but we also just add an applicability section. Wouldn't that also deal with the fact that the Boston Transportation Department is there? Are they on here? No, they're not. So even with that, they're not, the bike lane thing is a non-issue.
I think, Councilor, you're right on the solely piece, probably. On the bike lane piece, I know police department actually has their staff film those training videos so they can inform officers how to handle situations in those lanes as well. So I would leave it to the department to sort of talk about that work, but it isn't always the transportation department. I know they do it for the cadet program and other things, and they have a media production team there. I don't know if those people that do that production are sworn officers or not, or how that applies to civilian members of the police department. Probably some language there. As Cade was sort of recommending, I think we can come to find some good language that would sort of meet those needs there. On this line around sort of this component, I think you're probably right. The applicability maybe does sort of make that not a non-issue, assuming it's not municipal protective services that are, I guess, installing the camera for people.
Hi, Councilor Edwards.
Yeah.
I just wanted to let you know that I'm here, and I'm not sure if you can hear or see me. I'm on my phone. I wanted to just ask a question, but I don't know what order we're in, and I'm a little bit late to this, but I do have a question in the exemptions situation. So if it's okay, let me know when it's good to go.
Sure. And is it about this particular word solely, or is it just in general question? Because that what we were just discussing K, and specifically about the word solely. So we're looking at the red line on one section from the administration, and then no.
No, it's not about that. But it is in the exemptions spot, so I can wait.
Okay. All right. Let's. Okay. Thank you so much for the thank you, Councilor Mejia, for attending. Apologies. My camera's off because for some reason I'm sideways looking, so I didn't see a lot of other folks who joined. So my apologies. But on K, I actually agree with Councilor Arroyo. The fact that there's been some exemptions and some very clear definitions of where this will apply, if the applicability language is what we adopt, I think we're going to be okay with any overlap or concerning issues that the administration is bringing up several times. Unintended consequences, I think, was used in some of the other language. So we're going to go ahead and go on to, if you can scroll up, I think, to the next red line is O. So there were several exemptions with the administration, or excuse me, that we had. The administration has now added O, P, and Q. O being technology used only pursuant to lawfully issued search warrant or other court order or technology which is typically used only pursuant to a lawfully issued search warrant or court order which is used without a warrant, only during exigent circumstances as an exemption to this surveillance. And then also record systems which do not automatically collect data. And then finally, devices exclusively used for the purposes of detecting radiation. I will go to I guess my biggest question is what is the conditions of a search warrant or of a typically used search warrant situations? What is the distinction for, that would be my first question to the administration.
Council, so anytime technology is being used in a search warrant situation, the court, a judge is reviewing that and a judge is authorizing that. So as far as oversight, there's strict accountability and oversight through the court system for the use of that technology. So it's kind of, if I don't know if the council is looking to restrict it beyond what the courts have found to be permissible, but we're following the law. We're following case law, court decisions. It's approved. We're working with the district attorney's office. The district attorney's office is reviewing these search warrant applications, and then we're going to the court and getting judicial review and approval before taking any action.
Madam Chair.
P would be, so there's a question of just, so again, data and information, you could be talking about virtually everything we do. So our Mark 43, our record keeping system, that does not automatically collect data, really. It's all input. So is that subject, Mark 43 system, is that subject to this ordinance? Our booking system, again, that's not, it doesn't automatically collect data. It's, that's persons who are arrested by the Boston Police Department. And then, at the booking process, their personal information and information related to the crime that occurred is then inputted into the system. Does this, pertain to that? And then just the radiation, I'm not really up to speed on that system, but that's for, terrorist related incidents, we're in for, just say the marathon, when the marathon or other large events are run, they'll go through the area with a system that could detect radiation. Is that going to apply to this? And, any restraints? We're just trying to, if there's going to be an exemption, that's all we're asking for is exemption for those things.
Okay. Do you, and you don't think first of all, I'll ask the advocates about whether if there's already an issued search warrant or a court order, which would lend me to believe that there has been some sort of vetting and some sort of permission asking in terms of the violation of someone's privacy because they've been checked by a court. Does that feel comfortable or does that make sense? Or am I incorrect in that process?
Thanks, Madam Chair. So we strongly object to including O, and I'll tell you why. Obviously, technology moves much faster than the law, and we've seen in a variety of areas. I'll just give you one example. These devices that are called stingrays, they are devices that allow the police or the FBI or other members of law enforcement to trick cell phones into thinking a cell phone is communicating with the cell phone network, with a cell phone tower, when actually they're communicating with the police. And these devices enable the real-time tracking, physical location tracking of cell phones, as well as some models even allow for interceptions of communications from those cell phones. So this technology started to be used by police, 15, 20 years ago in some places, but because of a concerted, intentional strategy on the part of the FBI, judges and courts and defense attorneys and defendants were not even made aware of the existence of this technology until organizations like the ACLU and journalists started asking questions about it, and defense attorneys started filing discovery motions in court. So that's an example of a situation in which law enforcement essentially was engaged in a conspiracy of secrecy, basically, to shield the existence of a technology that would be subject to this ordinance from judicial scrutiny. And we've seen that pattern in other cases too, like with facial recognition, for example, which by and large has not been, the use of which by and large has not been disclosed to criminal defendants in courts, including here in Massachusetts. So, that's just one reason why we would strongly object to the inclusion of O. Another is, the council in its wisdom elected last summer to ban the use of facial recognition technology in the city of Boston. Courts, as you know, and all the attorneys on this call know, tend to have a binary response to Fourth Amendment issues. Either something is constitutional or it's not. They don't make policy decisions about what technologies are appropriate for specific communities. And so, those are the two big reasons why we would object to this. The other is that this would essentially shield, a large portion of the technology that is in use by the Boston Police Department from city council oversight and public scrutiny. And I think, for the reasons that I've described and for others, that's a major problem. With respect to P, that would shield the gang database from council oversight and scrutiny. I also think, the existence of the Mach 43 records management system is something that should be discussed publicly and approved by the council, in part because technologies like those often include add-on functionalities, including things like quote unquote predictive policing, which is a very controversial tool that police in many parts of the country have used. And then with respect to Q, I don't necessarily have a problem with this exception. I don't love the way that it's worded because it says exclusively used. It doesn't necessarily say that the technology is not capable of doing other things. So we might just want to look at the language there. But in theory, I don't object to Q.
Okay, so why don't we park Q for another time? There's just
Counselor, can I just say one thing?
Of course.
So the Boston Police Department does not spy on people. All right. We conduct our operations to protect the citizens of the city of Boston and those who visit. So, we get lumped in with, some things that go on in other agencies and across the country. And I think it's a little unfair to the personnel of the police department to cast those aspersions on us. And I'll leave that at that. Thank you.
I appreciate the comment. I think that the goal of this is to really get to how to make sure that we trust and move and are protected by public safety workers who work for the city of Boston, obviously as police officers, and work for all of us. And while the word spy may not be something that you appreciate, I think there are trust issues. There are many people who do not feel protected by, and they feel watched, and they feel that they are not, that they are suspected by the police. And so I actually think this is a very important work to make sure that we rectify that relationship and hopefully put us in the best position possible. Again, this is not telling you not to do your job. This is making sure that we're very clear about how the job will be done. So just looking at O, I'm going to ask again of Kate and the advocates. There's no check outside of the city council that you would be okay with in terms of the exemptions. So if they had a valid search warrant.
So
Kate, that's what I'm.
Yeah, thanks, Madam Chair.
Do you see where I'm going on that particular issue? P, I get, but how does that work if the court has issued a search warrant?
Well, there are a couple things here, right? One is if the police are getting a search warrant to use a particular piece of technology, as I said before, the law moves much slower than technology does. So, for example, in the state of Massachusetts, we didn't have any law, either through court jurisprudence or through statute, telling police that they're required to get a warrant to use that device that I just talked about, the Stingray, until very, very recently. And it actually only appears in a footnote in an SJC case. So it's still maybe not necessarily as clear as we would want it to be. So, one of the reasons why we think O is so dangerous here is because we would love to see policies be approved by the city council that would mandate by council order, essentially, that a Stingray is only used subject to a warrant, except in exigent circumstances. Because right now, we're essentially relying on a trust us statement from the Boston Police Department about not only the way that it uses the technologies that it has in its possession today, but also the way that it's going to use all future technologies. And the way that this is worded is very troubling as well, because it says technology only used or which is typically used only pursuant to a warrant. So anyway, for the reasons that I've said, and I think maybe Councilor Arroyo is going to add something too, so I'll stop now. Thanks.
Councilor Arroyo?
So I would just say in terms of O, as a former public defender, the way this works is if you're seeking a warrant to use some type of technology, they don't have defense counsel in the room saying why that doesn't make sense. What happens is they can authorize that, and then defense counsel can go after and sometimes succeed in saying why this shouldn't have happened this way. And so after somebody's charged or after whatever happens, and then that resolves itself later on in the process in terms of whether or not we get to a situation like Cade brought up with the Stingray. The reality here is just because a judge does initial sign off doesn't mean that later they're not going to determine that this was an inappropriate use or that this product is inappropriate in some way at some later point in time. And frankly, it would shield almost all, and I'm going to use a word here, surveillance, because that's what we're using. A lot of the surveillance technology that we would be seeking to be approved would be the kind of technology that you would use in a typical search warrant, because it doesn't say what level of situation we're talking about here in terms of the search warrant request. And the fact that it says typically used then opens it up even more because they're making the determination, not us, for instance, as to whether or not this is actually something that is typically used. It's a pretty big loophole problem on that front. And then with P, obviously the issue with the gang database, I think is understood.
Thank you. And I really appreciate the background as a public service attorney for folks to understand how search warrants are issued. At the end of the day, it would still allow for someone to be watched, surveyed, or observed. And the question is whether that information is allowed in court as to prove their guilt or innocence. But ultimately, the action isn't really checked and the process isn't really checked in how they access that information. So that really clarified it for me. So I don't see how, and it also would allow for them to skirt, I think, this whole entire process, just getting additional search warrants without defense. Yeah. Thank you very much. All right, moving on to section 3. Notwithstanding provisions of this ordinance, BPD Notwithstanding provisions of this ordinance, BPD may temporarily acquire or temporarily use surveillance technology in exigent circumstances for a period not to exceed 30 days. So this is allowing for some flexibility without following the provisions of this chapter before the acquisition. 1 second. Oh, sorry. And now I'm having technical difficulties. Can you still hear me?
Yes.
Sorry. Oh my goodness. 1 second. Sorry. Notwithstanding following the provisions of this chapter before the acquisitions are used. However, BPD acquires or uses surveillance technology in exigent circumstances. Under this section, the BPD commissioner must So in summary, this is allowing for exigent use, allowing for emergency use, but then follow up for the commissioner, they must do several things. So we have under A, report that acquisition, B, submit a surveillance technology impact report. And in that we have some red lines. So under B, it states, submit a surveillance technology impact report, and if necessary, a technology specific surveillance use policy to the city council regarding that surveillance technology within 30 days following, and this is where the red lines come in, either, which is red line, the end of those exigent circumstances, or 30 days following the conclusion of any investigation into criminal conduct related to the events given rise to the exigent circumstances. My first question, I think, to the police is, criminal investigations can last years, if I understand that. And so it's 30 days or until a criminal conduct is over, or the investigation into it. And criminal conduct isn't necessarily defined as that one individual. It could be several people in the room. So you could hop from one person to another person saying we're still investigating criminal conduct as an umbrella. So I really wonder if that is could perpetually delay the impact report. Thoughts from the administration and then the advocates?
Well, thank you. So I would think this would, as far as the technology, so this would be that like emerging technology. And I think going back to the previous under O, the concern for the department is kind of the tried and true. When I say tried and true, I mean, the things that work for us from a technology perspective, and that the courts have then upheld. The ordinance here seems to be that despite it working for us and despite the courts saying, given their approval, that the council then has the ability to go back and still say, well, despite all of that, if we don't like it, we're going to restrict you from using it. The emerging technology, if you want to put something into O saying, any new emerging technology has to be brought before the council, I think we'd be fine with that. And then if it's something that's, very new and, we're using it and it's in the middle of an investigation, there's going to have to be some type of, until that exigent circumstance is over, I think we need a little bit of leeway. It's going to have to be, and that could be, the working group is going to have to figure that out. I think there's just, you can't cover every single scenario of what might be happening by virtue of technology and incident. If it could be a life or death situation, and this ordinance we're not going to be allowed to use it. By the time we go and get the approval, it might be too late.
Well, I think that this is actually allowing for exigent circumstances for you to move and for you to get things done. This is about the report after the fact that the commissioner would have to define what happened, essentially, and it's allowing for 30 days following the end of the exigent circumstances in the original version. This is a report back to the community.
So that's
You're adding to that 30 days plus you're saying or after the investigation into criminal conduct has ended, and that's not really defined. And this is based off of my limited practice in criminal law, and I'm sure Councilor Arroyo and others can get in there. But I understand criminal investigations can last for years. If you're looking at organized crime, if you're looking at different things, and criminal conduct not defined could be for a lot of things. So that's why I think I could say I'm genuinely concerned about that. That really waters down the due date for the report. That's where that's coming from. But again, this is about you being able to go ahead and do what you need to do in exigent circumstances, just reporting back.
Yes, but if you go back to O, there's kind of a conflict there, and it's and I think that's why now this was put in there, and it's just the broad nature of this ordinance. It's impossible to to cover all the different scenarios. And that's kind of our concern, is because we're faced with so many different scenarios that in any given time, this is gonna tie our hands, and we're not gonna be able to do what we need to do to provide public safety at that time.
Madam Chair, might I?
Go ahead.
So I think you were exactly right, Chair Edwards, when you stated that the purpose of this section is actually to allow the police to use surveillance technology that is not approved by the council in emergencies. And that is very clear. But an emergency does not last very long, typically. There's typically a very defined beginning and end to exigent circumstances. That's what makes them exigent. You know, I think a great example, to use Superintendent Donovan's, is the Boston Marathon bombing. This ordinance would authorize the Boston Police Department to, for example, borrow surveillance technology from the FBI that has not been approved by the council in immediate response to an emergency like a terrorist attack. What it would not authorize the Boston Police Department to do is to then shield from council disclosure, public disclosure, and oversight that technology and the use of that technology for, as you mentioned, Madam Chair, the duration of a criminal investigation, which frankly could last forever. I mean, you know, we frequently hear from law enforcement that they can't disclose records pursuant to the Public Records Act, for example, because of an ongoing investigation, obviously a determination that's made entirely internal in the department with no outside scrutiny, oversight, accountability, or transparency. So that's our concern. We think that, you know, this section is very clear, that it very clearly allows the police to use unapproved technology in true emergency situations. But then all it says is you got to come back to the council and tell folks what you did.
Councilor Edwards, I just wanted to let you know, I'm sorry.
One second. Councilor Mejia, I apologize. You had a question about the exemption, so go ahead. And,
that was a while ago, and I think most of it has already been answered already. So I kind of wanted to just let you know that I've been notified that the live stream is not working. So folks who are tuning in are unable to do so. So I just wanted to give you the heads up on that.
Thank you very much. And I'll text with Carrie to see if we can fix that. Appreciate it. I can't recall someone. Oh, Councilor Arroyo, you raised your hand, and then we'll go to the administration afterwards. I think there was, yeah, go ahead, Councilor Arroyo.
Yeah, so I got two issues here. One is already been well touched, which is that investigations can literally last years. In fact, in some cases, I've had folks under continuing investigation even as we're winding through the legal process, right? So like, that's a very opaque sort of, like, that could be 10 years from now, 3 years from now, a year from now, or 6 months from now. Who knows when you're going to conclude an investigation? It's also a determination completely made by BPD. Nobody else gets to decide when they, quote unquote, concluded an investigation except for them. The other issue I have is in the language specifically that says conduct related to the events giving rise to the exigent circumstances. And the reason for that is with Afghanistan sort of in the news every day, if you want to look into this, is like the 60 words that authorize sort of endless war. And it basically is this. It's the idea that conduct related to the events of 9/11 allow us to continue to do things even against organizations that are well after 9/11. And it's caused this sort of endless loop. Criminal conduct related to the events giving rise is pretty broad. I have no idea how we would define criminal conduct giving rise to the exigent circumstance, or when we would say that those related events are concluded, because the related events aren't even the investigation. So that's those two things are sort of a problem, because it's two separate pieces to me. It's the conclusion of the investigation and or into criminal conduct related to the events that gave rise to that circumstance.
Right. Okay. I think the goal, again, is to make sure that there is an avenue to act immediately with technology that's not approved. That goal is still met. This language, I think, ultimately waters down the ability for BPD or for folks to hold law enforcement to come back to us with information within a timely manner, 30 days. Is there any movement or concern about the 30 days? Is there, if you felt you needed more time? That might be something that might be, but I can't see how we would just allow for the open-ended, never defined deadline for a report back. But 30 days.
So the language will be within 30 days following the end of the exigent circumstances. Is that correct?
Yes. So it could actually be more than 30 days after the use.
Yeah. Actually.
Yeah. Okay. It could be.
Okay.
It's within 30 days following the end of the exigent circumstances. But again, this is, just to be clear, exigent circumstances, and maybe we should have a definition section for what that is. I don't know if we cover that later at all. Actually.
You want to put that in the parking lot, Councilor Arroyo?
Yeah,
maybe
in the parking lot. That's for later.
For the definition, though, for exigent circumstances to be defined. Councilor Arroyo and to the advocates. Okay. Next, going down into looking for the next red line. So we're at D, E, F. So D, I'm sorry, is again about exemptions for emergency situations. If the commissioner of police is unable to meet the 30-day timeline to submit surveillance technology impact report, and if necessary, technology-specific surveillance use policy to the city council, the commissioner of police must notify the city council in writing requesting to extend this period. So there's an extension option. The city council may grant extensions beyond the original 30-day timeline to submit a surveillance technology impact report and, if necessary, technology-specific surveillance use policy. The administration added, if the council declines to grant this extension, the request for extension will be forwarded to the surveillance oversight working group, who will make a recommendation to the mayor. I can guess where you're going to go with that, Councilor Arroyo and Cade. Okay. To the administration, is it that you're just looking for an appeal process?
Yes, basically, yes. That we'd go to the working group, where the working group could, hopefully come to understand the situation from a public safety standpoint, and then the working group, of whom only one's going to be from the police department, would then make a recommendation to the mayor. So it wouldn't be the police department making a recommendation; it would be the working group. Whatever that group is comprised of. We would ask that there's at least one member from the police department on that group making the recommendation. Again, we're not making the final decision yet, whether it even goes further or if that's it. It's that's the end of the story there. Maybe it never even comes out of the working group.
I think what would be helpful, because I could see how this would be frustrating if the city council refused to act, Councilor Arroyo, if councilors were concerned with that. So maybe if there was a deadline, like, the city council must make, after an extension request has been put through, we got to take a stance. Because I can see also that never-ending deadline of certain people might be concerned about taking a stance if there's exigent circumstances, another marathon bond. There might, what I'm saying? There might be some people who are not inclined to just go ahead and say yes or no.
Yeah.
On the council. So go ahead.
And I think we actually have later in this in this actual ordinance that we can't just hold this in committee when they bring something to us. If we hold it past, I think it's 60 days, then it just automatically happens. So there is already something like that here. But my one issue, and I don't know if you were here earlier where they described, because it's a little confusing, because I think they have like the same name. They have two working groups like kicked around in here. So there's one that's proposed by BPD, and then there's another one that's sort of proposed by the administration for the other departments, and they do different functions, but I think they're both actually referred to as the Surveillance Oversight Working Group. And so they have the same name, do different things. And they have different things, basically in terms of so what I'm hearing with this is it's an appeal process, which obviously we would have an issue with. But then the one that the city was sort of talking about, Chris, and maybe you can pick up on this one, Chris, because it's on your side of this, was supposed to be more advisory and more like, hey, this is why we think it got rejected. This is how we think we could get this passed, and sort of a working group that doesn't have the ability to override a decision the council makes, but rather is trying to get something shepherded through. So that, that's different than a group that can say, we've been appointed to basically say this can get through even if the council says no. But I do agree that I think the issue you're bringing up is, what if they ask for an extension and the city council just says, park that in a committee and we're never going to talk about that ever again. I do actually agree that's probably going to be an issue. So I don't think that there's since we've done it earlier, and I defer to the advocates on this, but I do think that setting a time limit for it would be fine for us to answer or respond to that request.
Okay. We'll put that time limit for D for city action, in the parking lot, if you will, or whatever. I don't know what we're calling it. And again, I think we're still, from my coming in, there are still discussions about the working groups. The advisory ones seem to be a different discussion versus one that was kind of either a check or the appeal process to the city council. So I think until that's actually worked out about the role, I think it's going to be very hard for my colleagues to want to have that a check on them. But I'm happy to make sure that we have to respond and submit the request. So E, as red lines, it states currently, any surveillance technology impact report, and if necessary, any technology-specific surveillance use policy submitted to the city council under this subsection shall be made publicly available on the city's website upon submission to the city council, unless doing so would jeopardize the public safety or impair ongoing investigations. Is the suggested language, unless doing so would jeopardize public safety or impair ongoing investigations. I don't know how most information submitted to the city council isn't part of a FOIAble public record to begin with. So I don't know that language would actually be applicable, councilors, or to Cade or to the administration, that we could say only to us and for our confidentiality. We have certainly done our best, for example, when it came to retirement or the home rule petitions for 100% disability. We've certainly done our best to keep the medical records of the officers private, but we were very clear, because they're submitted to us for public discourse, they could be FOIA'd. So I don't know that we can write in an exception to public records exemption. I don't know. I'm saying that, Paul, excuse me. I'm so sorry. Is it superintendent? I'm sorry. I want to make sure I have your title correct.
Superintendent Donovan.
Superintendent Donovan, yeah.
Yeah, Councilor, so it just depends upon, the specificity of what the council is looking for, how much detail they're looking for, and then how much of that detail is going to be disclosed. If what's disclosed to the council is all in public record, then that could jeopardize that ongoing investigation, future investigations, how technology works, what exactly we have. Again, it's, the details. How specific are we going to get here? If we're talking about in very general terms, then that, probably won't be a problem. But if we're getting into, how something exactly works, what it looks like, that could be a problem for us. It could be an officer safety issue. It could be a concern for, victims and witnesses possibly. It's the broadness of this that's really kind of scaring us is what it is.
Well, I think in the submission of the request for extension of time, I think that would be the argument that the commissioner would be able to make. We need more time because of the specific concerns or this privacy issue or these particular survivors, victims that we're concerned about. I also think that there's, I'm sure there's a way in which certain names of people could be redacted we're not interested in actually, again, not speaking for the lead sponsors, but I know I'm not interested in the people involved. I'm interested in the technology that you use. And I think that is what is most important for me. So how much of a privacy interest do you have in the technology used, not in the individuals? Am I mischaracterizing your intent, Councilor Arroyo, or to the ACLU or anybody else? It's not about the individuals so much as what was used to observe them.
That's right, Chair Edwards. Yeah, so the ordinance does not require the police to disclose any information about any investigation ever, period. All it does is require the police to disclose information about the kinds of technology, surveillance technologies that they use or that they want to acquire. So I think, again, our problem with this language is that it would essentially exempt the police department from the ordinance, because obviously the police department would at its sole discretion determine what kinds of information, which types of technologies, transparency about would jeopardize public safety or impair an ongoing investigation. And just to touch on the example I gave before of the Stingray device, one of the reasons that the FBI gave for its secrecy surrounding the use of stingrays is they claimed, James Comey, actually, the former director of the FBI, publicly claimed that if the reason that the FBI didn't want police talking about this technology is because if bad guys, that's the phrase that he used, knew that the police could track their cell phones, I don't know, they wouldn't do crime or something. I mean, that was the argument, is like that maybe they wouldn't carry their cell phones with them when they were doing crimes. So, it's that kind of transparently false idea, I think, that leads to, a lot of concern on our part about the inclusion of language like this. People have watched TV, they know that the cops can track cell phones.
Well, again, just want to make sure we were.
Well, this is where that working group could come into play, where if there's a concern over an issue and where the council was going to vote something down because they weren't satisfied, that it could be sent out to the working group where some of these issues could be hopefully resolved versus just disapproved.
So I would just say, if I can, Madam Chair, I don't want to jump in without authorization.
No, go ahead, and then after that, I think I understand where most people's positions are on it, but
I would just say that an example that's actually relevant here about when I actually made a 17F request specifically for minimum staffing levels at BPD, which was very simple. Minimum staffing levels. What are the minimums? Not what are you staffing, but what are the minimum levels that you can staff? I did not receive that information because they cited that it would jeopardize public safety. So I couldn't even get staffing levels at BPD because getting the staffing levels somehow would jeopardize public safety. And so that's the kind of like open-endedness to that makes that literally would make this whole thing exempt if you just allowed that kind of language in here, because I think the same way that Superintendent Donovan has explained that he's worried about vagueness, even though I think this is much clearer than that because there is no interest in individual or independent investigations. I don't need to know that Mr. A and Mr. B and Mr. C were being monitored on March 5th this way. What I need to know is this technology is something we use to monitor. This is what it does. This is how we use it. And this is the additional ways it is capable of being used, point blank, period. I don't need to know the dates, times, the people, any of that. And this doesn't actually ask for any of that. But the vagueness that comes with language like jeopardizing public safety is way bigger and way more wide of a problem to me.
Councilor Edwards, I'm not sure if you could see me, but I do have my hand up, and I wanted to just say something really quick before you move on.
Sure.
Is that okay?
Yes.
Okay. So it's in regards to the way, and I'm not sure if this is the section that we can address it, but I'm hearing, and since we're talking about consent and folks knowing. I'm just curious, can we add a definition for knowing and voluntary consent? It comes up, I believe it may have come up or it's going to come up later in the document. But when a person provides their information, a lot of times people aren't really thinking about their data security when they're filling out paperwork. So I'm just curious if we can add language that either more accurately defines consent or creates ways for people to be more aware of their data security when they provide information to the city. Is this not?
No, I think that's we discussed a little bit on some of the voluntary and involuntary language a little earlier, and we have a parking lot of issues. But I do agree with you that there's a certain question still that we're working out on that particular language and that particular, like, what does it mean to volunteer? Obviously, you can't always check a box every single time, you walk around. So what does it mean to put yourself in that position? So I appreciate that. You did bring it up before for everyone to know. Councilor Mejia has been on this particular issue. What does it mean to volunteer and to be consent to be observed? So this is not inconsistent. You're bringing it up again, and we're in the middle of the back and forth on that throughout. And also, just to again give Councilor Mejia a shout out, we will make sure all of this and the notices and the understanding will be in more than one language, because if we're going to be asking people to be giving up or conceding or saying that the government can absorb it in any way, they better be doing it in a language that they can understand and make sure it's plain language. Again, a shout out for your efforts, Councilor Mejia. We're going to go on to section, continue on to the red lines. We were in F, which I believe has stayed relative. Yep. Now we're in part 4. This is, again, still part of the exemptions, emergency exceptions part. A city department may apply a technical patch or upgrade that is necessary to mitigate threats to the city's environment. The department shall not use the new surveillance capabilities of the technology until the requirements of this ordinance are, until the requirements of this ordinance are met, unless the mayor or their designee, that's a technical, the his or her has been moved to gender neutral, determines that the use is unavoidable. In that case, the mayor shall request the city council approval as soon as possible. The request shall include a report to the city council of how the altered surveillance capabilities were used since the time of the upgrade. That's where the original language stops. The additional suggestion from the administration: if the city council does not approve the use of this proposed new surveillance capabilities, the request shall be sent to the surveillance oversight working group, who will make recommendations. I think this is still part of the conversation about the appeal process. And yeah, I think that we don't need to rehash that back and forth. Moving on to B, in the original section, I think there's a B here. Was a B removed? Anybody? All right, I don't know why it's B in one and C in the other. Was B, is it typo? Was it supposed to be B in this version? On the
I think it was just a formatting fix.
Formatting fix? Okay, cool. Just making sure we didn't skip a section. That's all.
Yeah, I think we added applicability. That's why.
That's right. That's right. Thank you very much.
Applicability now, so everything should be one letter lower.
No, thank you very much, Councilor Arroyo. Surveillance use policy. The mayor shall submit to the city for its review and approval a proposed surveillance use policy applicable to each city department that possesses or uses surveillance technology before the effective date of this ordinance. The edits for the administration say that is covered by this ordinance. I think that we're working on that.
By the applicability.
Exactly. Okay. But again, there's the kind of appeal process. If the city council does not approve, the policy shall be sent to the surveillance oversight group. Again, I think that's the appeal process that we've gone back and forth on. So we can move on to the next set of red lines. That would be number 4. B4 on one version, C4 on this on the other. But The city council shall vote to approve or deny surveillance use policy by a vote of a simple majority. That's what the original language says. Proposed edits. The city council shall vote to approve or deny surveillance use policy by a vote of simple majority within 60 days of submission. If the city council does not approve the surveillance, that shall be sent to the surveillance working group. The 60 days is something that are you opposed to that?
I mean, it's just, that's a matter of.
I'm sorry. I'm looking at you, Councilor Arroyo. No one knows who the you is that I'm talking to. So, Councilor Arroyo.
So this gets back to the idea of timeliness. I really don't have an issue with being timely. I think I can't think of a period where the city council would have 60 days between meetings, for instance. That's 2 months. So I think you could have something brought in and then on for a vote within 60 days. I guess it's a question of where these things would go. Would they go to government ops? Would they go to public safety? The one sort of loophole that I could see here, the problem here is if, due to the way the council operates, if something goes to a specific committee, I can choose by myself never to bring it out for a vote. If somebody gets something in their committee and we create a mechanism where when we don't vote on something, it gets immediately passed or it immediately goes to some appeal unit, we are giving somebody essentially the single-handed power to say, I know my council colleagues may not pass this, so I'm going to hold this past the deadline so that these other things get triggered. And I do worry a little bit about that.
Right. Okay. To the advocates, beyond to Kate or to anybody else, are you okay with the timeline that tells the city council must act within a certain amount of time? I guess I would ask about the concept, not the 60 days itself, but just that the city council has to act within a certain amount of time.
Yeah, thanks, Chair. So we came up against this issue when we were discussing a similar ordinance with the mayor's office in Somerville. And we ultimately agreed that a timeline is appropriate. I think, what I'm not clear on is what happens if the council does not move within 60 days. I mean, I understand in the way that the administration has proposed, we address that problem. The subject would be sent to this working group for discussion. I think it might make sense to, there are two separate issues here. One is that we have to figure out what we think about this working group and its authority. And then the other is whether any sort of automatic thing ought to be triggered. And I agree with Councilor Arroyo that, if there's someone in a position of power on a committee who supports the passage of a surveillance use policy, but thinks that maybe their colleagues will not support it, that they could just sit on it for a couple months and then, it would automatically be approved. So that's certainly a concern. I think, like with many pieces of this ordinance, there's a trust that the city council is going to behave responsibly here and, not use the powers granted to the council in this ordinance in ways that are inappropriate or that would put at risk vital city operations. That's, as elected officials, I think it's sensible that we adopt that kind of like trusting approach because, the people of Boston would have the power to throw you out of office if they think you're using your authority. So yeah, I mean, I think I'm fine with a timeline. I'm not really clear on what exactly happens if the timeline is surpassed.
Okay. Would it be that if we fail to act, that they can just go ahead and move?
Well, I think as Councilor Arroyo pointed out, the danger there is that somebody who has a view that the surveillance use policy falls short of what the majority of the council thinks is necessary could just sit on it for 60 days, avoid a vote, and then, would automatically be approved by the council. So I actually don't object to the language that the administration has suggested here, because it doesn't explicitly, include any trigger like that. It just says, you guys need to get your acts together within 60 days. And if you don't, then the working group's going to have a conversation about the proposal. I mean, that doesn't bother me.
I will say the one question that I have is, because there's two working groups on the table, one that sort of is supposed to make recommendations and work towards how do we make, is this something that can get passed or something that should get passed? And then they make different recommendations to try and shepherd this through. Another working group is one that's sort of been detailed by BPD, which is more of an appeal process that they can override a decision we make or get around or whatever that is. If this is simply sending it to a working group that is going to try and look at this and try to figure out, how do we shepherd this through, or how do we get this done, or what is this thing? That's a totally different deal than if we don't vote it and it just gets authorized, right? So I think part of it is just understanding these working groups as they're seen by Chris and Paul, because they're two different visions for what these working groups do and how they're even formed.
Superintendent?
Yes, thank you. So, I mean, the BPD would not be overriding anything. Would have one person on the working group who would be making the case for the police department to the working group to go back to the mayor to work with the council to get this passed in some form. And that's all. We wouldn't, we're not going to get anything approved. We're just trying to work through the process.
So just to be clear, I don't mean BPD itself can somehow override the council. What I'm saying is the working group that you're proposing, in your vision for this, is it something that can approve a request that the city council denies, or is it something that just sort of is similar to the city's version, which is a working group that's supposed to make recommendations on why they think it didn't get through or how we could get it through?
All they do would make recommendations to the mayor as to, how to maybe make some changes, explain it better, justify it, whatever it is. And then it'd be up to the mayor to go to the city council then and say, we need this in, some form, we need this. And it'll be up to the mayor and the city council to decide where we go from there.
So, Chair, I can just say from the advocates, I can't speak for all the advocates, from the ACLU's perspective, if this working group is merely providing an advisory role to the mayor about how to address city council concerns with the materials that the administration have forwarded to the council and has no overriding authority in terms of overruling any decisions that the council makes, we're fine with that.
Okay. Okay.
Councilor Edwards, I just have a quick question and a clarifying question in terms of who is, and I may have missed this, but in terms of who makes up that working group?
We parked it. We're parking that to still define what that is, but they have some suggestions and we have some too.
Okay, I just want to make sure that.
It has not been defined for me.
Madam Chair, can I offer one sort of clarification from Councilor Arroyo's point?
Yes.
So the secondary working group, the establishment of a surveillance data and privacy working group that sort of falls at the very end of this ordinance, the intent of that is to think about the implication of those things, surveillance data and privacy, for all the other departments that are not considered in the ordinance at hand, and to make recommendations to the mayor and council on processes that we put in place. We have lots of thoughts on what that would be, but want to do that collaboratively with community partners, with the council, with departments inside City Hall. So that's the intent of that working group, is to chart a course on, maybe the year ahead of all that work that needs to be done with those other departments.
And I'm assuming that's why in the language that particular one disbands as opposed to permanent.
Correct, because the goal is to sort of create policies that are then sort of embedded inside the operations of departments and the city at large. Correct.
Okay. All right. Thank you. We're going to go on to the next set of red lines. This is in surveillance technology impact report use policy. Mayor's office must seek and obtain approval from the city council as set forth in this section prior to the city acquiring, using, or entering into an agreement to acquire, share, or otherwise use unapproved surveillance technology or surveillance data as defined in this ordinance. Section A then goes on to say, the city may seek but not accept funds for surveillance technology without approval from the city council. Again, may seek but not accept, provided that the city shall notify the city council of the funding application at the time it is submitted and include in its notification the deadline for the funding opportunity and details, if specified. As a suggested edit, regarding the nature of the surveillance technology for which funding is sought. The next suggested edit, if the city council declines to accept funds, it would go to the working group to make recommendations. Again, I think we just had a good conversation about what is working group advisory versus appeal process. I think advisory is, I don't think anyone disagrees with people being able to get together in a room and think about it. I see Councilor Arroyo is shaking his head.
No, I don't have any disagreement with that. I think that's fine. If it's an advisory capacity, absolutely. I think the override capacity, so this loophole or this appeal process is a totally different conversation. But just having a bunch of heads in a room trying to figure out how to get something done, I mean, that's what we're doing right now. So I don't have any problem with that.
Okay, and I think it's fair that as technology is going to change rapidly, we should want people who are dedicated to figuring out brokering a deal or brokering out concerns in the city council versus law enforcement. I actually don't mind that either. Okay, if specified, I don't know, is that because you think to the administration, you think some applications don't have all of those details? To the advocate.
Sure with that.
I'm sorry?
I'm not sure what that, if specified, was meant for.
It just seems like you're covering to make sure that not all applications may have the exact information, but that's how I read it.
Chair, yeah, I mean, for similar reasons to what we've discussed prior in this conversation, we would object to the inclusion of if specified, because we think that there ought to be details in these materials.
All right.
Can I just ask a question on this, a clarifying question? When it says the city may seek but not accept funds for the surveillance technology without approval from the city council, what does that even, like, what's that mean? Does that mean you can
put it in
like,
an application?
Yeah, when you say you can seek it but not accept it without the council, I mean, we are the purse strings on whether or not you can accept or change money, right? Like, as far as I understand it, in terms of the council, we have oversight over every dollar released to the city. So is this one of those situations, like, for instance, when we have grants where we pay for that and then we reimburse it on the back end? Is this a workaround on that? Or what are we talking about specifically when we say the city may seek but not accept funds?
So, Counselor, I can address that. This came up in work we've done in other cities on this matter. You know, we wanted to make sure two things. One, that the police, for example, can't kind of work around the requirements of the ordinance by using federal money or private money, even from like a private foundation or something, or a donation to the Boston Police Department to get around the requirements of the ordinance, right?
So this is for grants, basically.
Yeah, exactly.
Got it.
Exactly.
All right, clear,
Yeah.
done.
Okay.
Got it.
Cool. Okay. Moving on to 2. It looks like if you could, thank you so much. The language edits seem to be simply clarifying, just putting in where the administration puts in section 1663.1, which is the applicability or the definition of what it applies to. The advocates put in the word applicable. So this is just a writing style difference. So we'll figure out what makes most sense, whether we're going to do section referrals or just applicable. But
So
we can move on.
the section referral here was because they didn't have, to their credit, the departments didn't have the applicability section that was added in this one. So they had to do that. But now I think applicable makes sense because there's an applicability at the top.
Agreed.
Okay.
Agreed.
Okay. All right. Next, for the next set of edits. Great. So we're now in, thank you. A little bit, let's see, we're at 2.
So that's 3 on the, no, wait, that's still 2.
2. Acquisition of surveillance technology by city department, exempted, or could you scroll back up again, Michelle? Sorry, thank you. Acquisition of surveillance technology by city departments listed in section 16.3 are applicable. Unless exempted or accepted from the requirements of this ordinance, any city department, the applicable city department, intending to acquire new surveillance technology or surveillance data, including but not limited to procuring the surveillance technology without the exchange of monies or other consideration, or use surveillance technology or surveillance data for a purpose or in a manner not previously approved, shall, prior to acquisition or use, obtain city or council approval for this acquisition use. The process for obtaining approval shall be as follows. And then they go through three steps. Well, actually, there's many steps, but the first A is the department shall submit a surveillance technology impact report. B is if the request is approved by the mayor's office, the mayors shall submit the request. C is where we see some edits. The city council, and in the original version, it says the city council shall have 90 days from the date of submission to approve or deny a request by majority vote for the acquisition or use of surveillance technology. Suggested edit from the administration is that they should have 60 days from the date of submission. And then, of course, if the city council does not approve acquisition, to the working group. So it's really the question of 60 versus 90, and that the working group is more advisory. We'll go to the advocates. Is there 60 versus 90? What is
So thanks, Chair. I would defer to the sponsors on this one. I mean, you all and the council have a better sense of your workflow. And if you think 60 days is sufficient, it's sort of a similar comment to the one I made earlier. There doesn't appear to be any automatic trigger that says that after 60 days, it's automatically approved. So it just seems to be like a recommendation to the council to do this within 2 months. And so I wouldn't personally object to that.
Councilor Arroyo?
Yeah, again, I don't, as long as there's no automatic trigger, I don't have any problem with saying, please get this done in 60 days. And I think, frankly, if there's no automatic trigger, there's no incentive for somebody to sort of play politic with it and hide it or do anything with that because it doesn't gain them anything. So I think that's fine.
What are the implications if we don't act in 60 days?
It looks like the implication here is that they want it sent to an oversight group that will have an ability to make recommendations to the mayor as to how to maybe get it passed or done. I'm assuming if we don't get it done in 60 days, there will be a solid reason, right? So for instance, most recently with BRIC, we had questions they would not answer. We had things they would not do with that grant. I'm assuming if we hold on to something for that deadline, it's because there's some stated reason or purpose that we could very easily have a working group hash out so the city council doesn't have to, and then they come back to us with whatever we're seeking or whatever the issue is. I would assume that's how I read this, and if that's what it is, I don't have an issue with that.
Okay. I'm fine with the 60 days, honestly, and oversight committee. So moving on to D, which is next, contents of surveillance technology impact report. Surveillance technology, oh, I'm sorry, this is E, excuse me. Information describing generally the surveillance technology and how it works. That is one of the parts of the report. I don't know, generally, is anyone opposed to the word generally?
Chair, yeah, we would object to that. I mean, for similar reasons to what I mentioned before, having more information, I think is better. And the word generally, I think is open to a lot of interpretation.
Okay. We can continue down.
If I can jump in there for a second, Councilor.
Absolutely, Superintendent.
So that gets back to the specificity and the details of what the council is looking for, and then the ramifications of that as far as, public information. And that's what we're concerned about. So I heard earlier, we weren't looking, it was described as kind of, we're just looking for the general of how this stuff works. But now when we insert the word generally, it's not acceptable. So again, how do we kind of define what this ordinance is going to require us to submit to the council, and what level of detail?
Chair, sorry, go ahead.
I just want specifically what the product does. I don't want to know generally what it does. I want to know specifically what the surveillance technology does, not a general understanding of what the technology does. I don't need any specifics about, we used it on March 3rd. Well, in this case, it was a drug bust, and and Mr. Doe was in his house, and this is how we did it, and this is what we did. I don't need any of that. What I need to know is what the technology does specifically, not generally, and what its specific uses can be, not what its general uses are. We generally use it this way. I want to know specifically how it's used, not who it's used on or when it's necessarily been used. I just need to know the information regarding the applicability of this surveillance and what it does. That's specific. And so when we say general, I think there's this worry that somehow we want to get into your ongoing investigations and figure out, are you using this on a Wednesday at 5 p.m. on Mr. Doe? I don't care about that. In the sense that I don't need that level of specificity. What I care about is this technology something that is capable of doing X? Does the city use it to do X? That's what I'm trying to figure out very specifically. Does that make sense, Mr. Donovan? Superintendent Donovan?
It does to some degree. It doesn't, alleviate all of our concerns. But if we're going to, if we're going to move towards this working group, I think when an issue arises about the details that are required to satisfy the council, and the police department is hesitant to provide those details, maybe that's something where we can, send this out to this working group, and they can hopefully, hash things out and then come back with the information that's going to make everybody happy without just, getting it approved or disapproved and, people aren't happy. So I think the working group is going to be a key component of this thing, and because we're not going to be able to cover every single scenario in this ordinance. There's some things are going to have to be very, the group's going to have to work it out and then come back with a recommendation that then hopefully satisfies everybody.
Thank you.
Sure. Yeah, we wouldn't object to that, but I don't understand why that means the word generally needs to be in here.
Well, if it sounds to me like it's not going to be in there, but again, as long as we have the working group to kind of fall back on, I think we'll be satisfied with that.
Yeah, I think for me, where I'm at in terms of, because I think we've established now that this working group is not an appeal process or some kind of overriding loophole, but rather an advisory thing to make something meet our standard of what we're looking for, or at least to answer the questions that we may have on it with a group of folks in a room. I see no issue. I see an issue with the word generally, but I see no issue with the idea that if we reject something because we do not believe it's specific enough, that working group can have a whole conversation about that. I don't see any issue with that I can foresee with that.
I don't either, and I think the working group will very likely have to be a living, breathing group that grows, as this ordinance will be doing that as well. There's nothing. There's going to have to be changes, but we're trying to get ahead of technology that doesn't even exist yet. So I think that the working group as an advisory makes sense. We're going to work with the 60 days, is what I've heard. Is fine, Councilor Arroyo?
Yeah, that's fine with me. The 60 days, especially if it's going to be a working group, because I just assume if we don't get something done in 60 days, there's a reason that we can give that working group. It won't just be, we were so swamped we couldn't do this. The only time I can see that, being honest, is we have a budget season, and we have that sort of booking something during that budget season can be a little bit difficult. And that budget season is longer than 60 days. But even then, we get things in when we have to.
Thank you. Okay, so we're going to keep going down. The next set of edits. All right. This is referring any surveillance technology impact report and if necessary technology specific surveillance use policy submitted to the City Council under section 16.1663B and 1663C shall be publicly available on the city's website upon submission to the council. Unless disclosing it, this is the suggested edit, unless disclosing it would jeopardize public safety or impair an ongoing investigation.
Yeah, this is the one we already discussed about the language, and I think we don't have to rehash it.
Yeah.
Same objections.
Does council rest? Same objections. I just heard it sounds like in court. So next to 1663.4 Boston Public. So now we're in the Boston Public Schools policies, and I know that there's some advocates specifically on school policy. We didn't get deep into this the last time, so I'm really excited to get into some of these suggested edits. Is anyone from BPS here? I didn't check.
Yes, Santa Pina's here, Chief Copley Grice, and Mark Racine.
Thank you. Are these red lines from you?
No, these are also from Boston Police, but in consultation with us, so we jointly collaborated on them. So
okay, just want to make sure who I turn to for the explanation of the red lines. That's all.
okay.
All right. So school police officers shall not collect, store, or share information pertaining to students except by creating and sharing student reports in accordance with this chapter. Student reports shall only be created when serious bodily harm to an individual has occurred as a result of willful conduct. That stays the same. The next section, a true and credible threat to the safety of the school arises. That language was stricken. Instead, it says a threat to the safety of the school arises. That's one we're going to discuss, true and credible being excluded. And then C, it says a student is in possession of firearms. The suggested edit is firearms, ammunition, or other dangerous weapon being added. And then D, a student lawfully possesses or uses controlled substances provided those substances are not marijuana, nicotine, or alcohol. The suggested edit being provided, however, that a school police officer may collect, store, and share information on students suspected of unlawfully distributing marijuana or alcohol on school grounds. And finally, E is added to say a student is involved in an incident of sexual assault or sexual abuse as defined by Massachusetts general laws. Let's start with the words true and credible. Why would the administration want to strike that language?
Counselor, just so we have to determine, I mean, many threats are determined not to be true, and in some cases, they're not credible. So the only way to determine that is through an investigation. And if, a report's not being generated about that threat, then how do we investigate it to determine if it is true and credible? And then take the appropriate action.
So you think you're putting the cart before the horse? You're basically saying you're saying you don't know if it's true and credible at the time of collecting the report.
Yes. Okay. Yes, we need to know about it. We need to be notified of it.
And I would just add that we need to treat all of them as a real threat until proven otherwise. So it's important for us to investigate all threats.
Mm-hmm.
To the advocate or lead sponsor?
I think that we've heard stories from people, including Liz McIntyre, who couldn't be here today, from GBLS, about how threats can be such a broad word and how it can be used as students say things that maybe they shouldn't say that can be treated like a threat. And she has a story about a student who was agitated and said, I'm going to bring the ocean to flood the school. And a court order was given for that. And the student is not going to bring the ocean to flood the school. And so that would still follow under a threat. Another example she had, and this is actually something that has happened to me, is saying, this class is boring, but it would be more interesting if I shot someone, which is clearly concerning, but also situational, that no one thought that they were actually going to shoot someone, but someone overhearing it could and say that's a threat and needs, and criminalizes someone for trying to get a laugh. And so just saying a threat, we think, is too broad and allows a lot of teenage behavior that we wish maybe students would not say things like that, but that could potentially criminalize them.
There must be a way in which we can get between the two, I feel. Because I just from my thoughts, the shooting incident that you brought up, actually, I think doesn't help the argument about the threat language. True seems to be too high of a standard.
So that's where I was at.
Credible would be, okay, go ahead.
I think a credible threat to the safety of school is fine. I think we don't have to have true and credible, because like that ocean thing would not be something I would consider a credible threat, right? And so that would sort of be dealt with appropriately. The true might be too high a standard. But I think credible has to remain, right? It has to be a credible threat. It can't just be a threat. Can't be I'm going to hit the school with a meteor tomorrow. Like, it has to be a credible threat. And I think that's fine for me. True might be too high a standard, but credible, I think, is where we need to be. It can't be a non-credible threat. And it can't be something where we look at it and we say, really, somebody said they're going to flood the school with the ocean and you sent that over to, ICE or whatever. Like that can't be a thing. So I think credible's fine. I think true and credible might be way above. And so I think it's fine to take out the true, but credible has for me.
I would be okay with that.
If I can just add, Madam Chair, on our end, as we investigate all threats, depending on the outcome of that investigation, it would move forward in any proceedings or not, right? So as we investigate threats, for example, in the case of the ocean, it would be deemed a code of conduct issue and refer to the code of conduct and move forward. If and only if the threat investigation yields that there was a crime involved, then in that situation, it would tend to move forward. So that's how we looked at it. So I just wanted to add that piece. Thank you.
Thank you. So I have from advocates they're willing to kind of compromise on the word credible, but taking out true. And I understand from the administration that they just want to be able to take everything as a collective, investigate, and then get to that, whether it's credible or true after the fact. Thank you. We're going to go on to C. It stops now if a student is in possession of firearms. The administration is asking for ammunition or dangerous weapons. What are the concerns with adding that? Ammunition, I don't know that that's a big deal. The dangerous weapons being not defined is a little harder for me, but I understand the reason why it's there. So thoughts? Counselor, the lead sponsor.
We're on C where they define possession.
Possession, yes, ammunition or other dangerous weapons, that language.
I'll let the advocates discuss the ammunition part, but for me, just bringing like practical experience into this, I have had some ridiculous dangerous weapon. I had 2-wit dangerous weapon plate of Chinese food. That is a real case I had. 2-wit dangerous weapon, Q-tip swab. Like, I've had wild dangerous weapons because the interpretation of that legally is so wide. And so the problem with dangerous weapon is that it's too vague, even though it sounds very specific, a dangerous weapon. But it's actually not very specific. It's actually very vague in legal practice. The ammunition aspect of that, I don't know how often folks are finding ammunition without firearms. But I would leave that to, I know we have teacher advocates here, and so I would let them sort of discuss their stance on that.
Thoughts on dangerous weapons and ammunition to the advocates?
Thank you, Madam Chair. We would agree with Councilor Arroyo. First of all, we are assuming that the administration intended to put a comma between firearms and the word ammunition. But either way, we are not in support of adding the word ammunition. If a student comes to school with a bullet, that's not going to hurt anybody without the actual firearm. And our concern is about the safety of the students. And in terms of dangerous weapon, again, would be in complete agreement with Councilor Arroyo that is actually non-specific and not actually going to be helpful in keeping students safe. So we would not support adding in dangerous weapon.
Would there ever be a definition that you or Councilor Arroyo would like dangerous weapon meaning, and then listing the following that we consider dangerous weapons only?
I mean, you could probably try to do that in a definition section where you say, you know, like, for instance, here's the issue in terms of like getting into this part is a dangerous weapon is often in like, how can you, so for instance, with Trayvon Martin's case, right, to be very specific about what's been legally argued in court, they argued that the asphalt of the ground was a dangerous weapon that Trayvon Martin had access to in his fight for his life, and tried to argue that it was self-defense on the basis that he was hitting somebody's head against the asphalt, which was a dangerous weapon. And so it's that even trying to define it specifically, like for instance, I can tell you what I would think is a dangerous weapon if you're bringing like an actual sword or something to school with the actual intention and purpose to use it, not because it's show and tell day, right? But like to get into breaking down what those things are is really tricky, I would say. It's kind of the problem. It's very subjective.
No, you're right. It's usually anything can be a dangerous weapon if it's used that way, right? The definition
my pen could be very deadly, right? Like, so there's a problem with that. My pen, right? I have a very sharp pen. So like those are the kinds of things that if I use that as a knife, that could be called a dangerous weapon. Or the plate of Chinese food was because this person threw Chinese food on a person, right? So like it's just, I don't know how we would specify that in a way that makes sense. I do know, obviously, we don't want firearms in school. So that's why that's there.
Excuse me.
Yes?
This is Chief Coakley. I'm sorry about our video today. Not feeling too well today, but I thought this was very, very important. So I just wanted to really be a part of the discussion. For our lawyers in the room, we know that dangerous weapon is very specific in mass general law. I have not been in a circumstance in which a Q-tip was denoted as a dangerous weapon, or even a plate of Chinese food. They can be used dangerously in that description. Any case in which we've had for students that were in possession of ammunition, just to counteract the notion that if an ammunition is present on a student, there's automatic assumption that there's not a weapon. I don't think that we could legally think that and safely think that if a student's in possession of ammunition, in which we know, what would you have an ammunition for? Probably possession of some type of firearm. So we'd have to conduct an investigation. Where that investigation goes, I don't think that's conclusive, but I think that still denotes an investigation. For dangerous weapon, there's a very distinct list in mass general law of dangerous weapons. I think we go through that category. And if the weapon is not listed on that, and if it's used dangerously, we can categorize it as that. So I just want to be clear with that. I don't want it to be this general conversation.
I appreciate that.
And I just want to be clear too, because maybe this part wasn't heard. Those were two cases I actually had to defend in court. Those were real cases. I didn't just pick those out of thin air.
Yes.
Those were two charged cases in the state of Massachusetts.
Yes. And so I'll just be totally transparent. I don't know the ammunition is what I'm having, like not excluding it is what I'm having a struggle with. I think I think it was Chief Coakley. I'm so sorry.
Yes, ma'am. It's Chief. It's Neva.
Chief. Yes. Your comments on, if you find a bullet, that as why that wouldn't prompt an investigation to find out what it's to or where it could be. I think I'm having a harder time with the bullet. The dangerous weapon part, I think is I'm happy to try and park that for a definition or to define it distinctly what we would say are the dangerous weapons that warrant a investigation in a school, I'm happy to do that. But the ammunition part, I think I'm kind of pushing back a little bit on the advocates. If we see bullets, you are correct. A bullet in and of itself can't do much, but neither, there are a lot of things. But I think it would, why me as a person, a parent, or another student wouldn't want to know, like, you saw the bullets, why didn't you ask? Why didn't you follow up? Why didn't you start something with that information?
Yes.
Paulina?
I would just clarify that this ordinance does not regulate any sort of investigation that happens within the school. It does not mandate that a blind eye is turned to these incidents, but rather this is regulating reporting to the Boston Police Department. So there's a difference here that perhaps was not being, that I just wanted to emphasize.
I appreciate that. And I think it's worth still. Go ahead.
Also, we would have to.
My apologies. Go ahead.
I'm sorry, Madam. If I can real quickly, just in the light of the definitions around dangerous weapon, in our code of conduct, we do have a list of specific dangerous weapons that we refer to. And I know legally there is a list of dangerous weapons. So maybe a compromise here can be to look at that list. And we just generate a list based on those two lists and see what we can agree to. But we have it clearly spelled out in our code of conduct. I know there's a legal list that we use with through Mass General laws.
Thank you. That I will. Let's park the dangerous weapons conversation to compare the two. Councilor Roy, if you have a commitment from you.
Yeah, that sounds good. That sounds good to park that and then look at the list, and I'll see what the BPS list is, because if they're specifying it already in specific ways, there might be some things there to look at.
Thank you. And Superintendent, you had your hand raised. My apologies.
Yes, just so, yeah, I think we can work on that dangerous weapon list. It's certainly, it's in the statute, the state statute. There's a list of it. City ordinance is a knife 2.5 inches or greater. And then, it's possession of a dangerous weapon. So a Q-tip or a plate of Chinese food in and of itself is not dangerous. But yet, if you commit a crime, if you stab somebody in the eye with a Q-tip, now it becomes a dangerous weapon. If you throw a plate of hot Chinese food on someone's face, that then can be a dangerous weapon. So it's possession of what is in and of itself a dangerous weapon, not any item that could be used as a dangerous weapon.
A very fair point, Superintendent Donovan. That actually is a very fair point. That it's a possession issue, not a assault or whatever.
A use definition. Okay.
And as far as the ammunition, I think you really need to include ammunition. It's ammunition in and of itself, especially in a school setting, is inherently dangerous. It can be. You don't need a gun to set off a bullet. It can be discharged without a firearm. If you hit the primer in the correct fashion, it is going to go off. You could have another kid in the school, you could have someone else, they have the firearm, but they don't have ammunition. So you could have another kid bringing ammunition to school to provide it to the kid who has the gun. That's a potential happening. So I would urge very, very strongly to include ammunition, and we can clean up the dangerous weapon description to satisfy everyone, I think.
Appreciate that. And I think we're going to get to, I think, a good compromise on that particular language. Appreciate the back and forth. And again, reminding us we're not stopping looking. We're just the reporting aspect to the police. Though I do think some people would still want to know that was reported to the police, the bullets were found or something like that. So,
well, I think at this
also,
point,
Madam Chair, just for the collection of that item, we would not want ammunition to be collected and then just arbitrarily stored. Anyway, we'd have to turn that ammunition over to law enforcement.
Anyway, is that the law? Anyway?
Yes, ma'am.
Okay. So D, there is that a student unlawfully possesses or uses controlled substances, provided those substances are not marijuana, nicotine, or alcohol. So you're not going to collect information unless the student unlawfully possesses certain controlled substances those substances are not marijuana, nicotine, or alcohol. However, the language provided by the administration is that school police officers may collect, store, and share information on students suspected of unlawfully distributing marijuana or alcohol on school grounds. Advocates and the lead sponsor.
I think that there needs to be some sort of minimum amount in this, because while I don't want kids dealing, and I think there might be law about school zones that could help inform that. What I worry about is, someone buys a small amount of pot and someone chips in for it and they divide it up in class. And then while there's lots of counseling that BPS has around that, I don't think that warrants a police report. So I wonder if there are minimums around school zones that we could look to around this.
But we're not talking, so the possession of it, right? If I purchase it, the possession of the pot is not
right,
going to be.
Right, but if I give half to a friend, is that distributing?
I see.
Like, in this, yeah.
Technically, it is. So if you, technically, yes, it is. Now, I would think that, some discretion and common sense in the school on how to handle that would be, so this, again, this is about the ability to, it's not saying that it shall be reported to the police. It says it may be reported, I believe, right? So again, I think the police, certainly in that scenario, we would hope that I think the school would handle that situation and not really even involve the police in that. It would have to be, maybe it was an ongoing thing where it kept happening, maybe would be involved, or if it was, a much larger amount, then you involve the police. I think we'll leave how to handle that initially up to the school, but just that it can be documented. If according to the ordinance, it can't be as written unless we amend this. It's not going to be documented and then won't be reported at all.
Right. Okay. So the may collect, then I think the administration is saying that it's not a required, but they may, and it provides some discretion to the advocates, to the lead sponsors. The may enough?
I think I would also want there to be a minimum, because what I've seen is that while I would hope that people would use their discretion in doing that way, that looking across we have many schools, and I think there, things that, the ocean, you would think that someone used their discretion over like Ocean 2 flooding the school, but that did get to a report. And so I do think that there needs to be some minimum so that there's some guardrails there.
I would also just say one of the things here is students suspected. So this is how we got into this problem sort of in the first place, is that we had students suspected of being gang members, right? And then they ended up being deported. There was no proof of that. I think part of the issue here is not that it's stopping them from investigating anything. So just to be clear, this doesn't stop them as school police from investigating a single thing. But if you're just suspecting somebody of distributing marijuana or alcohol, I'm assuming that means that you don't believe that you have what you need to go beyond quote unquote suspecting. And I don't think we should be sending suspecting reports to BPD on unless we put a number on this marijuana that makes sense. But for alcohol, for instance, I mean, what is that? Is that like as a charge? I don't even know if that's a fine. Like, I don't know what that is. So like in terms of suspecting these things, I don't think that should be going over into a police file, because we've seen how that can get used in an immigration proceeding against somebody, even though it's not verified. Something that's verified at a certain amount, I don't think we would have an issue with in terms of having discretion, because it's a may, not shall. But I do think that one of the things that stands out to me is that it says suspected rather than verified or any other sort of official language on that.
Okay. All right, then. So go ahead.
I mean, there's I look at, so there's the creation of the report and then the sharing of the report. So one, I would like to see that the report is first created. And then it's up to, I guess, the school department, whether or not they then share that report with us, depending upon the, you know, the level of severity of the incident. I don't think it's mandating that they share it. I guess it's gonna be up to their discretion, whether or not, with ammunition, I think they do have to. I mean, it's possession of ammunition is, if you're not licensed, it's a crime. So if it's,
Yeah, I don't think I spoke on this, but I think we're going to be fine in terms of including.
Yeah, the same thing. I mean, the drugs, again, possession of marijuana, but if you get up to a level, if then you can't possess. No one can possess it legally. In distribution is against the law.
So just to be clear, Superintendent Darwin, I don't think we're disagreeing. What I'm saying is, by that standard, you wouldn't suspect them anymore because they have a certain amount that after that amount, which by the law, this is how it works. After that amount, it's presumed that it's for distribution, or the way that it's packaged. It's not suspected as much as it's just like you have to now rebut it, right? Like it's a rebuttable presumption, but it's different between saying, I think this person sells marijuana. I don't know it. I don't have any sort of information. I think they are distributing marijuana is different to me. And that's what suspected means to me. Then I have documentation and proof and sort of a case here that a witness or somebody has told me, and I've verified this in some way, shape, or form. That's different to me than saying it gets right back to, I think this person might be a gang member. Nobody's verified it. I haven't verified it, but I think it's the case. And then it's just, instead of gang member, just say distributor of marijuana, right? So like, I do think there's a way we can get here where there's a guardrail on amounts or whatever, and then it's still up to discretion. But I don't think as written it's there right now.
If I can add this context to just help the conversation and help get us to a place where we can kind of compromise. In Boston Public Schools, we prohibit marijuana and alcohol use in general, right? We do not want our students and or staff members possessing or using alcohol while on school campus. So as such, and with that context in mind, we want to make sure we fully investigate cases where appropriate, and where cases that distribution is involved, we'd like to minimize that as much as possible. So we do have safeguards in place of how we can determine through our nurses when students are under the influence and are suspected to be under narcotics, and we have those procedures in place. Whether or not it rises to the level of a police report, again, we want to make sure we're documenting cases where alcohol and or drugs are involved, because we want to make sure we track and monitor and provide interventions and supports to students who may be suspected of use or distributing. So I think it's important for us to document it. Clearly, we can do that in our SIS system, but when it rises to the level of criminality, to the point which is already defined with minimums, we can go there. But I just want to make sure we understand that we do not prohibit alcohol and drug use in schools.
So the clarification is that we don't allow marijuana or alcohol on school grounds?
It's prohibited. We don't allow it. So, I mean,
I thought that was just assumed. Okay, so I see what you're saying. But yes, what I'm saying is, I think there's a difference between being able to have the school police investigate or do what they have to do or make a report on by the standards of BPS, and then sharing that report with another agency. I think there's a real big difference on what we think should rise to the level of what gets shared. I don't think under any situation the drinking alcohol for which I mean, chances are they're likely a minor, right? 18 under, but maybe they're not. I don't think that rises to the level of something we would want to send over to BPD, right? So I think there's room here for us to find compromises and be fine.
I agree.
I just think there's specifically in terms of my issue with this is the sharing component, right?
Yeah.
So that's where we're at.
But we can the reporting
common ground on this.
We can find common ground. I'm sure we can.
I'm sure.
Okay. So just moving on to E, sexual assault and sexual abuse. Again, this is because we're in the reporting requirements, right?
Yep.
Creating and sharing student reports, but this student report shall only be created when, and then we're in the following thing. So sexual assault, sexual abuse,
I had one question about this, which is my understanding is BPS is a mandated reporter.
Right.
This, right? Like they already got to do this. This is my understanding.
That's correct, Councilor Royal.
Yeah, so you already got to do it by law, right? So we're not trying to remove that. At least I'm not trying to remove what you already
So
have.
why don't we just refer to the Massachusetts General Laws mandated reporter section?
That's fine.
That's fine. It was just, as written, it said shall only be created when it listed in sexual assault wasn't covered. So as long as
no, fair enough, fair enough. But I think we can write something in there to make clear that this doesn't in any way, shape, or form interfere with mandated reporter requirements, because I think literally you don't have a choice in that, right? So that is what it is.
And if I could add, I'm sorry, Madam Chair, and as we're talking about the as mandated reporters, there's also a level of neglect and categories that are in that mandated reporting that we may also want to consider here as we look at that.
That's the parental neglect stuff, right? Yeah, all that stuff. Obviously, mandated reporting is mandated reporting, and I don't see why we would try to interfere with mandated reporting.
All right, we're going to go on to number 2. School police officers may not create a student report relating to matters that are not described above, is the current language. A suggested edit is without permission of the superintendent of schools.
I mean, for us, we go back to, the policy and the bill reform of the police reform bill, right? So our school police officer staff or Office of State Service staff, we're referring to them now, they're unable to write police reports any further, right? So any documents that we create relating to these are just conduct issues and matters. So if it rises to the level of needing to be transferred to BPD, we put the safeguards in place with our data sharing policy that will follow.
I think so I'm going to let the advocate speak on this one too, but I do wonder if we did this, there'd have to be some mechanism, some reporting mechanism where we understand how often the superintendent is authorizing or doing certain things. It doesn't have to be with specific people. Obviously, there's protections in place for names and things like that, but we would have to sort of have a way for us to keep track of whether or not this is a rubber stamp and she's always doing it or he's always doing it, or if it's or they are always doing it, or if there's some sort of pattern in terms of what is being overridden, right? Because this is literally a loophole that says anything can be written as long as the superintendent says sure, right? And so I think there does have to be some safeguard on that, absolutely.
And the only other piece I would add here is superintendent or designee, only because it may not be the superintendent all the time. For example, it could be me, or it could be, because right now the current policy reads the chief of safety services is the only person that's authorized to transfer any data to the Boston Police. So we can play with the language a little further, but I agree, we definitely should put measures in place to track what occurs beyond this scope. I agree.
Okay. So we will work on that. You said you wanted to.
I see our advocates are trying to jump in.
Yeah.
I'm sorry.
Mm-hmm.
I don't understand why this loophole is necessary. And we disagree with the addition of this loophole, especially if it includes the superintendent or her designee. We would really be in staunch opposition to that, because that allows for the further rubber stamping and diffusing of responsibility. For the precise reason that Mr. DePina mentioned before, there seems to be no reason why the school police officers, the school safety services employees would have to create a student report. That just doesn't seem to me like it would fall under any of these categories that we have already listed. So if the administration has an example, I'm just unclear as to why this would be required.
And we're happy to strike it. We're just trying to reach a compromise and put it on the table. I mean, there really doesn't need, our safety service officers no longer required or able to write police reports in general. So we can't do it anymore based on the change in law. So the only incidents that will be reported through school administration on code of conduct matters. So happy to strike this sentence.
That'd be great.
Thank you.
Thank you. Okay, moving on to the next set of edits or red lines. Okay, all right. So this is student reports shall not contain information pertaining to, it lists several things, including immigration status, citizenship. It goes on to suspected, alleged, or confirmed gang involvement, affiliation, association, or membership. That was in G. That's where it stopped in the original version. In addition, includes unless gang membership is related to a specific criminal act or is related to a threat to school safety. I can guess where the advocate and Councilor Arroyo will be with that that clause. So why don't we just go ahead and go to why don't we go ahead and have the administration explain why that clause is necessary?
Thank you. So there could be an incident where the gang membership is an integral, component of the incident. If it's, say the kids getting recruited into a gang, whatever gang, X gang is trying to recruit this kid in, or there's two warring gangs, and it's A gang versus B gang. How do we having that information in the report and then conveyed to the police is critical to responding to that in a timely fashion. If it's just, Johnny and Jimmy, Johnny's threatening Jimmy, and there's no mention to the gang involvement of it, we're not getting the whole picture, and it won't be handled appropriately in a timely fashion, potentially. So I just would ask that for a specific criminal act or threat to the school environment, that be included. If it's just in general terms, that the kid gets into some incident in school and he's a known gang member. Okay, it doesn't have anything to do really with gang activity, then leave it out. If it's not pertinent to that incident, just leave it out. Don't include it because it's not really relevant to the investigation.
And if I can add, we have had many instances over the years where we do have rival gangs come up to schools, come up to school grounds after school, before school, and sometimes it's named that this gang is coming up to the school or this crew is coming up to the school. So for some level of prevention support, it's necessary to be identifying some of those gang affiliations to help mitigate the threat to the school and the rest of the community. So that's why I agree with this language.
To add additionally, some victims have disclosed that they were victims based on the fact that they were not a part of a certain gang or were a part of a certain gang in some respect.
Okay. So advocates and Councilor Arroyo.
Well, I can take a stab here. This is Elizabeth. Just to go back to superintendent's examples, unfortunately, the many examples that we've seen of police report of any kind of reports coming out of schools, when you're in your example, Jimmy and Johnny are just like having an argument and it has nothing to do with gangs. Particularly with Black and brown students, it is often labeled as a gang issue when it wasn't. Similarly, when, I think that is the biggest issue, and it gets distributed to other organizations, other agencies, can be pulled by other agencies, including ICE. And it does significant damage. And there is no way to defend against it once it's been rubber stamped, if you will, by law enforcement before an immigration court or before other agencies where the burden of proof is much lower and the assumption of criminalization is already there. And so I appreciate concerns about safety. I guess I don't see why, when you have a report in front of you that's coming out of a school, someone can't call a school official and get more information to flag any, certain risks that may exist with a particular incident. It's just that by and large, gang membership has been over included in reports, and that has done like vast amounts of damages to communities of color.
Okay, I understand that. And I guess what the police department is asking for is the school, the school officers, the school staff to assess that incident and best they can. If they determine, there's a fight between two students, and one may belong to one gang and one may belong to the other gang, but they just got into a fight and it doesn't have really any gang involvement, then they can leave that out, and they should leave it out. It's only when someone at the school determines that this act, a criminal act or a threat, is related to gang activity, the police department feels that should be documented. Now, we're not saying every incident involving a kid who is a gang member is a gang incident. It's not. Someone has to assess when that is and isn't, and then, document it appropriately.
I don't agree with you, and I don't disagree with you in theory, but in practice, what I see is that incidents that are not gang related are labeled as such. And it is, again, particular to communities of color.
All right.
If I might add in, I think there's also the question of how do we know that they are gang members and not, do the school police officers have access to the gang database to verify they are gang members? Never mind, the problems with the 10-point system. I mean, we won't go into that, but, students say things to posture, for their own safety, to be cool. Like, that's how teenagers are. And so I think this allows for a lot of assumptions that may or may not be true to become reports. And, Elizabeth has spoken on how dangerous they can be.
I would just respond by just saying many of our officers don't know unless a lot of this is self-disclosed during gang-related activity, right? So most of our officers have the firsthand knowledge of an incident that occurred where gang affiliation was disclosed by students themselves. And I think in that regard, we have to be able to discern and or mitigate the threat to the school or community based on that knowledge. And I think documenting it once we know it's either self-disclosed or to prevent and mitigate a threat or a situation between feuding or rival gangs, it's important for us to be able to do and know and document.
Okay. Well, I think if there's confirmed, I think we've had more incidents than not of how this definition and how this affiliation or suspicion or kind of being related to gang activity has resulted in more harm, honestly, than good in terms of students and how they're wrapped up into a system and defined for an undefined amount of time, not only at the student level, but at the school level, but when it's passed on to other agencies, which we still are waiting for that data, I believe, Councilor Arroyo, how that person is forever in that track of life. And that's what I think we're trying to prevent, because there's a certain stigma after that school report that was, being affiliated with, what if my brother's in it and I'm not? That there's so many different ways in which you could be affiliated around it, totally dependent on where you live and your communication and your family members that you have no control over. Your locker mate. your classmate, you're like who you choose to, sorry, Councilor Arroyo, who you choose to, I don't know, who you go to church with. I mean, there's so many different ways in which affiliation could be part of it. And to be a confirmed gang member, unless you're part of the membership committee of said gang, it's very hard to know who's truly confirmed. I mean, I know there's some people who are out with it, but I mean, let's be very clear. We're talking about this. We are very concerned because we've been on the other end of that slippery slope.
Yeah, and I would just add everything you said, everything that was said by Ms. Badger, but also we know that self-identification on the gang database system, even as is, we have their checklist. It's one of the lowest points totals. Like saying I'm in a gang is actually one of the lowest amount of points you can get in their structure. Like you get points for being around people, wearing paraphernalia, but the saying you're in a gang is actually not the highest method for determination of being an actual gang member, which tells me that even BPD understands that people can claim or say they are part of a gang, and that in and of itself is not enough for them to dictate this person is a gang member, because they clearly have some criteria that they have looked at or they are using to say, we know that this isn't worth much to us as compared to these other things. And so I know that the gang database has a place where they give points for whether or not you're a self-proclaimed gang member, and it's not the highest one there. It's actually not, I don't even think it's in the middle pack. It's not that high. They don't give it full credence. And so even in this case, I fall on what Ms. Badger said and you yourself, Ms. Chair. Thank you.
I'd urge you to come up with some kind of exception to that. I don't know what would satisfy you, but you know, the shall means never, so never means no one knows about it. And I think it would be important to have some exception built in there where the gang membership in certain instances could be documented.
Especially if it's tied to criminal activity. I mean, that's for me the underlying thing. Connected to a criminal act that occurred. But
well, tied to a victim, that gives that as part of a statement. So now we're going to eliminate that if the victim says, "Hey, I was assaulted," or say, "God forbid, I was shot because I'm associated with this particular gang or group." Do we eliminate that from that report now? Is that what we're saying?
I don't think anybody getting shot in school grounds isn't going to make it to BPD.
No, I'm saying even if he's not in the school grounds, but he's coming back into school, which we have a number of individuals that are doing that.
That's a fair point. And so what I would just say is the one thing that I'm highly conscious of, is the issue that sort of got us here is a cafeteria fight with somebody who was allegedly a gang member, that was a fight that was possibly gang related. And that's what got us to the place where we ended up with a person deported from BPS on the basis of those two things: school fight, possibly he's a gang member, and possibly this is gang related. That's the report that went over and got us here. That's also the report that we've seen go through the judicial system. The case name is I'm missing it, that led to issues with the gang database in general. And so this is one of those issues where I guess part of my problem with this, and I'm just going to be very blunt about this, is I think what the intention of, say, what the school police want when they want to document something, and what BPD wants when they document something or share something with each other, is not necessarily the intent or the way that it is used by an organization like, say, ICE, when they have the same information. And you can't control how or what they do with it. You just know they're not using it the way you intend it to be used, or the way that the Boston School Police intended to be used. But because it exists, they're now able to use it in the way that they are seeking to use it. And what this is trying to do, at least as far as I'm concerned, is ensure that we don't have these issues or circumstances where you have a specific purpose that you believe is narrowly defined and very good, and maybe even we agree. And then ICE or some other organization comes in and uses it for their very specific purpose that we would all say, whoa, 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 we didn't mean that. But you can't stop that train from going once it leaves the station. And them having that document and being able to receive that document is a real problem. And so I think that's really, for me, the whole gist of what we're trying to prevent is I think there's real places where, in good faith and with good reason, BPD or the school police do something or want to document something. I also understand as an attorney, as somebody who's seen how this works, that those documents can get places that we don't intend them to get, and they can get used in ways we don't intend them to get used. And it's very harmful when that occurs. And so we have to create some safe rail or guardrail to ensure that that doesn't happen from other places. It's not even necessarily how you use it or how BPS, the school police, is trying to use it, but that the fact that the existence of it can be used in a way that harms children. And so that's the real issue, that as I see it, and trying to figure out how we deal with that.
I see your point, Counselor, and I'm just, the unintended consequence of, solving one problem, you fix this problem, but in doing so, you kind of create another one, not immediately, but by virtue of another incident, because we're restricting documentation now, it causes problems down the road in another incident.
And I would just add, the data we don't collect is all the interventions and issues and threats and criminal activity that we curb or prevent based on known
tornado warning.
So fortunately, we don't collect that data, so it's hard for us to say that it works. But that's our position. But thanks for the dialogue. Good dialogue.
I don't know where you folks are, but I just got a tornado warning on my phone telling me to take shelter. I'm at headquarters.
So I'm in Hyde Park. I did not receive that update.
I'm gonna step out, see if anybody else got this. I'll be right back.
Yeah, we did too. We have it as well.
I got one in JP. I might rejoin on my phone so I can go downstairs.
Yeah, I mean, I'm in a pretty, although I'm on the top floor, so I might go to a lower floor. So,
no, I just wanted to say this. I totally respect your opinion and your logic, Councilor Nahara. And our policy, our new policy, is really strictly adhered to, and it speaks specifically to this in the reporting of this. And so we're going to be definitely paying closer attention to in our annual training on this. Just wanted to add that point.
And I appreciate that very much. Thank you, Chief Coker.
Nice, it's on the news, the whole city.
I may have to step out. I just want to check transportation and some of our other items out there real quick.
Likewise, I got to check in with some folks on my end. Sorry, guys. I mean, we are at 1 o'clock. I'm sorry, Madam Chair. I don't know how we want to handle this, but we are at 1 o'clock. And I know we're deep in the conversation, but given the circumstances.
Yeah, I understand. I've heard some of the warnings. So we're going to continue on and to try and finish this today. The whole thing.
Okay.
So
I understand
you have to step off. I understand people may have to step off and on and so on and so forth. We're going to continue on with the red, with the
I
edit.
will also just say there's not a whole lot of red line after this. Like if you go, it's
that's
it's
why I
a
want to
lot
get to it,
paper.
Councilor Royo.
Yeah.
I agree. I don't want to.
Could you scroll down, Michelle? Just keep scrolling, please.
Yeah, if you just go down, it's not a lot.
Thank you. Principals and heads of school of the schools where the subjects of the reports are enrolled, and the school where the school police officer writing the report is assigned to work must receive copies of all student reports written under this section immediately upon writing. Within 24 hours of the writing of the student report under this section, the relevant principals or heads of schools must provide a copy of the report with any necessary redactions to protect student privacy to every student referenced by name in the report, as well as to those students' families. Provided, however, the reports required in this report may be withheld if disclosure jeopardize ongoing investigation. Reports which involve allegations of parental household abuse may also be held from students' families if disclosure of the report is not in the best interest of the student. So the change, of course, is jeopardizing ongoing investigation. I think we've discussed that extensively in the previous section. And then the reports involve allegations of parental household abuse may also be withheld from students' families I think I think that might be normal part of your procedures. Those reports, because you're mandated reporters.
Yeah, I separated that too. So it's funny, you see the same thing I did. That's a separate sentence. I had no issue with that sentence, but I also think it's covered by mandate reporters, right? Obviously, we don't want a child who's saying I'm being abused at home to then have their parent notified that they made that statement at school, right? Like this is, to me, I thought that was just covered by mandated reporting and didn't have to be said, but I don't have any issue with reports which involve allegations of parental household, because I'm assuming that can only come from the victim themselves, i.e. the students in that school setting. There's no way that a parent is coming in and reporting it, or you're seeing some form of abuse from a parent literally right in front of you. I separate that from with the rest of what we're talking about here. And I just thought that would fall into mandated reporting.
Okay. I don't think there's any controversy then. So we're moving on to the next red. I think it's in number 3. This is regarding BPS personnel or school policy officer transmitting a student report created pursuant to this or any other information relating to a student to BPD, or to any other entity outside of Boston Public Schools in accordance with sections 1663.4C1 or 4C2, the following must take place. Student named in the student report and their parent or guardian must be notified in writing that they received in writing that they, pursuant to 1663.4A5A, will be transmitted to BPD or to the outside agency, receive an explanation of why the information reflected in the report is being prompting the communication. And all written materials must be provided in both English and the language spoken by the relevant student's parent or guardian. Again, we have the caveat provided, however, that such disclosure need not be made if doing so would jeopardize an ongoing investigation. I can only see that again with regards to mandated reporter concerns if the parent is the abuser or the family member is the abuser. But other than that, I think the family should know if any aspect of their child or a report about their child is being sent to the Boston Police Department or any other agency.
The only flag I would take is that, or just agree with the language. Just want to flag that there sometimes is a delay in translating of documents. Not delay, but like it takes time to translate the documents. So I'm just wondering, when we say provide that, we do want to do it. Definitely understand why it's important and we do it in other areas, but just generating that translation sometimes takes a little time. There's a little gap there that we want to make sure we minimize and figure out how best we can either communicate it orally in the language initially, and then maybe follow up with a letter once it's translated, that kind of thing. But just want to flag that for folks.
Madam Chair, would this have been addressed by what we did yesterday?
I was going to say, I believe so. Yep. And there are already caveats in the new language access ordinance that actually provide for within do best efforts and some sort of language that does assure that ultimately there will be some flexibility if necessary for certain languages, but absolutely that there is a allowance for some sort of, if there's a slight lag time.
Thanks, guys.
Okay. Moving on to the next one.
I just have one comment on that. So beyond the investigation, that could certainly jeopardize an investigation, but it could also jeopardize, student or school safety, potentially. Say it's regarding a threat to the school. One student comes forward and says, Jimmy's planning, he's talking about he's going to do to the school. And he's advised of this before, the investigation proceeds or before there's, safeguards put in place. There's got to be some type of plan and evaluation of this before there's an automatic notification to the student's parents. There has to be some consideration about the, what's going on here versus there's an automatic notification going on. There's got to be an evaluation and, an assessment of it, depending upon the severity of it. If it's some minor thing, then yeah, but I could see this being a problem. Higher level incident.
Could that be covered under the exigent, if it's an exigent circumstance? I'm sure this would happen after that was over. I think
a worry we have, sorry, my camera's not on. I'm in the basement because of the tornado warning. I think the worry we have is that, investigations, as we talked about earlier today, can go on for so long. And I know that, Elizabeth, who I think had to step off, has talked about how, getting police reports for her clients, often it says, she's told that, it's under investigation or it can't be released. And so I think we want to make sure that, if it's an incident that has that there is a moment that you're doing a threat, that's one thing. But if the report is written, that's probably somewhat after the case. And that then the student should know that this has happened, that the report was written.
Okay.
It's all the timeliness of it and what else is going on. Yeah, I see the need for it, but there has to be some careful thought and not just like kind of automatic, boom, they're notified.
Okay. I think we have the exigent. I think we can mirror some of the language of the exigent circumstances.
Okay.
And some of the balances of that.
Yeah, I agree.
Okay.
We're going to keep going down. Probably could scroll down. Again, this is the caveat language that we've discussed, but within 24 hours after BPS personnel or school police officer submits a student report created pursuant to the section or any other information relating to a student in the BPD pursuant to the existence of exigent circumstances, the relevant principal or head of school shall notify in writing any student whose information or student report was shared and their parent or guardian that the student information was shared, and a copy of the information transmitted and an explanation of the incident prompted the communication after the information was transmitted. All written materials must be provided in both English and the language spoken by the parent or guardian. And this is again adding the caveat, but I think the exigent circumstances, we can marry that.
Okay.
If we could scroll down. Okay. The creation of the Community Information Sharing Oversight Board was in the original version. And the original version, or the first draft, I should say, the board includes several positions, a student chosen by the Boston Student Advisory Council, parent or guardian by citywide parent council. We have several different positions I don't need to list, a teacher chosen by BTU, local immigration advocate, and a immigration advocate chosen by SIM, Student Immigrant Movement, a civil rights advocate chosen by Lawyers Committee for Civil Rights, and one representative, this is the edit suggested, one representative chosen by the Boston Police Commissioner. The advocates have a problem with that. I think that was also part of the advisory board, kind of mirrors what we did or what they suggested before for the advisory board, having at least one member of the BPD.
Yeah, that's just to give the perspective of the police department and,
No, yep. Yeah. I'm sorry, go ahead.
Oh, I guess my question is that this feels like a school matter, that we're talking about schools transmitting reports, and, there's a whole other issue of, what BPD does with it. That's what the rest of the ordinance is. But, why there needs to be a BPD officer on something that's looking at schools,
Well, the language that they state isn't actually requiring a BPD officer. It's one representative chosen by the Boston Police Commissioner. We're assuming it'll be a police officer, but it could be Chief Coakley.
Right. Yeah. I guess my question is what need they feel like that is filling if it is about the transmitting from schools. And I know there's a form of this committee now that I'm a part of. And I think a lot of it is talking about what's going on in those schools and having a holistic approach to that. And I guess I don't really see where there's a need for that.
I think the need would just be that from, the public safety perspective, that something could arise that, we could, the benefit of our training and experience. We could provide some advice or counsel that may make, the school environment safer. And I mean, the general neighborhood, the city safer. I mean, what happens in the schools often translates onto the city streets. So, there's some responsibility there to be involved on the police department and, offer, advice and counsel. And again, actions or decisions sometimes have unintended consequences. And if we could point out, say, okay, that's, that works well here. It works well for that reason. You've corrected that problem here, but that may lead to other problems elsewhere. We've seen this. And again, I mean, we're not carrying, we're one voice there is all we are. We're not, that's all.
I guess like two things, and then I will leave it up to the council, but I think two things. One is that this is an oversight board that's looking after the fact about data of the reports written and making suggestions looking at the data. And I think the second thing I want to bring up is that, our hope is that we have a lot of diverse members of the group, including a lot of students and parents of color and, people with different immigration statuses, and different people in our community have different relationships with the police. And so if it is a police officer, like what are the relationships that those people have with the police, and how could their participation in the board maybe not bring their full selves to it if they feel like they are giving information that the police would then be privy to.
I'm thinking we just follow our suit of inclusivity and partnership. And I think this leads to that mission.
Yeah, I agree.
Also, this is an advisory board about the implementation, right? So I don't know if there's a voting structure on this board, if there's a majority, but if it's just one representative presenting a perspective, then I don't know. I guess I'm trying to, what's the argument of not having them at the table to at least provide the perspective?
I guess my worry is that there are certain members of our community that don't always feel comfortable around police officers. And so if they are not able to bring their full perspective to this group, like I want to prioritize students of color and undocumented students. And those students often have sometimes complicated relationships with the police department. And so my worry is that they won't be able to bring their full perspectives.
I mean, this would be a way of starting to bridge that gap a little bit. And I would imagine, not speaking for the commissioner, but, we have our Bureau of Community Engagement, who deal with, have all kinds of activities going on with the kids. This would probably be an ideal position for someone from that bureau to represent the department. They're very sensitive to the needs of the whole community and students, kids in particular. So the person would be selected very carefully, I'm sure, and would be, Superintendent Baston's a perfect example. I mean, she runs that bureau. Everyone loves her. She gets along with everybody, and that's the type of person would be looking to put in that position. And then just again, offer the law enforcement perspective in a kind and gentle way that, is going to build relationships. That's what we'd be looking to do.
I agree, Superintendent.
As well. And Madam Chair, just on a separate but related note about the membership of the group, I wanted to save it for this time to discuss it. So in this document, we have 2 working groups that are established, but I also want to just name that in our Boston Schools Department policy around information data sharing, we also created a student data working group that's tasked with doing something very similar. So I just worry about the coordination amongst all the groups. And so there's some continuity and some, just collaboration, because I just worry that we have these different groups and how they're communicating and what they share, how they share. We're also finding in that group there's certain information we do collect and don't collect that we've kind of sorted through over the months. So just wanted to flag that for the group too, to figure out how we like navigate all those, and should there be just one? Does there need to be multiple? Just a thought for the group to consider.
So I have a couple questions. One question specifically, because I'm seeing it on the list, but I'm not really sure who it's made up of. The groups as it's written right now include the Code of Conduct Advisory Council. Who is on the Code of Conduct Advisory Council? Is that not a BPS group in terms of BPS? So who is?
There's a separate. I can give you the membership. I can't quote them all verbatim now, but there's a lot of parents, advocates.
So it's not staff.
Some staff as well. No. That's external. You're right. No staff is on that group. No.
Okay, that's my only question, because I haven't seen that particular group before on that front. I think the concerns of advocates specifically around having undocumented members and them being concerned about that, I think is valid. I would also just say we just did, so this is kind of where we got to get into like the language of this, because they're all these oversight boards, but Community Information Sharing Oversight Board, we have a OPAT, which we just did, does not include some provision for the BPD to put somebody on there to have a conversation about what we do when we do oversight of BPD. That's the whole purpose. And for me, the Community Information Sharing Oversight Board, the purpose isn't to figure out, whether or not something the idea isn't to have somebody make a case that we should be sharing information. I think the idea is so that we can make sure that we're enforcing this. And I don't necessarily know that a representative from BPD on a board that's goal is to ensure that there's oversight, that this is actually being conducted, necessarily makes sense, because of the same reasons we didn't include that in the OPAT situation, right? Like ultimately, this is an oversight board, and you're asking the people who are being overseen to also participate in the oversight. And I don't know that makes sense for this particular board.
Okay, I think that's fair, and I think that there's also. This is a creation of this board. And I think, like I said before, the other, as we've already talked about the advisory board for the other aspects of this overall legislation, we might get to a point where the perspective of BPD and some public safety, law enforcement folks will be at the table and advising. But if the biggest core concern of this was that the two be totally separated, that education and BPD be separated, I think it's worth maybe just not having it be a member of this perspective or this advisory board at this time, at this level. But they are a member, as I understand from the other two working groups, a member in some way, shape, or form, or having a voice there. Is that correct, Councilor Arroyo?
Yes.
Okay. So let's just continue on. We're now in annual surveillance report. We have the applicability section, which I think is going to deal with some of the concerns on the other side, really specifically concerning the section shall only apply to the city departments and agencies, Boston Police Department, Boston Public Schools, Boston Health Commission, Boston Housing Authority, Boston Municipal Protection Services, and the Office of Emergency Management. That's added on the one side to narrow the scope. And then we have, moving on in comparison with the original language, within 12 months of the effective date and annually thereafter, all applicable city departments shall submit to the mayor an annual surveillance report. The edit suggested is within 24 months of the effective date. I think, so the issue is 24 versus 12 months.
It's weird because they crossed out 18, which wasn't on there anyway. So it's 1 year, not a year and a half, not 2 years. I think 2 years is a bit much.
I actually think that 1 year is within the effective date. Within 1 year, there'll be an annual report going forward. And I think that I don't know why 1 year is not sufficient time. The administration or someone could speak to that.
I mean, in my perspective, and just to respond, when we implement it and launch it, there also has to be a lot of conversation around putting these logistical monitoring these monitoring tools in place. So we need to make sure that they're established and created. I know for us anyways, we had to create a way to generate our reports, collect the reports, and it was time needed to do that. There were also just organization time that we needed anyway, that was making progress on. So I'm not sure what that looks like on BPD side, but we're gonna need to figure out how we implement the monitoring aspect of it, and that may take time. I do want to make sure that we're reporting regularly, so we establish quarterly meetings and check-ins along the way to provide updates, but sometimes we may not fully be able to do that right away. I think the 18-month is a good compromise because it gives us time to just organize ourselves and make sure we're able to provide the reports and information we need. Or the first thing a report will be, here's where we are with implementing it and where we are. So either way, a year report can happen. But I just think if we want a full, accurate report and all the pieces are correct and in place, and the extra time helps us do that.
Okay. All right. So so just more time is better. I think.
Especially the first year. Let me be clear, just the first year. But going forward, definitely yearly.
Okay.
I think for the police department, I mean, I agree. We're, at the police department, we're kind of in flux here a little bit now. We're looking at, it could be another 6 months before we have another permanent police commissioner. It's kind of, the unknown right now, with the election coming up, we're not sure how that's going to play out. Weren't sure, we haven't dug into this, fully, and, what's going to be, how much work this is going to entail to compile all this information.
Okay, so I think 18 months is a compromise. I'm fine with it. Councilor Arroyo?
I mean, I'm not really sure how you can't get this all in order in a year, to be honest with you. I don't
know how an extension in then put it that the
So that's what I was going to say. I think we had language earlier that gave extension, you could request an extension on the report, right? I think we had that.
All right.
That's
earlier, and I think that's sure, right? But I think I just want to go back. Let me just try and find it. We might even.
Okay. Yeah, if you can build.
I don't want to hold this up. I know we have it. We'll look at it before we ever get to vote on it.
Okay.
We'll have a conversation with that. But I think we came up with some language earlier today on extending the annual review, and there's a process we created for that. I think, sure, I don't see it here, so we could do it here too. So if there is some kind of issue where it makes sense to extend it, you're given this opportunity or this way to do that.
Okay.
Thank you.
Okay.
That's helpful.
All right. There's also a point for which they wanted to add in.
General, this is sort of a reoccurrence of what we dealt with earlier.
Sorry, Chair.
Before then, the Surveillance Oversight Working Group has made recommendations to that language before that. You'll see that it says that the shall submit to the mayor an annual surveillance report pertaining to each city department for which approval of the use of surveillance technology or surveillance data has been obtained under section 16.3, or for which the Surveillance Oversight Working Group has made recommendations to the mayor. And that seems a little bit of an override.
That's what I was going to say, Chair. Yeah, we would object to that language. That's what was making me so confused about what the Surveillance Oversight Working Group's purpose was. So yeah, we would recommend that not be included.
Okay. And then now to Councilor Arroyo, to your the general conversation.
Yeah, so we already I feel like we already covered this. I don't want a general description of how surveillance technology has been used. I don't need, and we've gone over sort of the details.
All right, that's fine.
And then, so number 2, or continuing on with number 1, general, but then including the sound, images captured, other information regarding members of the public who are not suspected of engaging in unlawful conduct. That language was stricken out. I think we're just trying to know what you captured. So information about me walking down the street when you were really observing a friend of mine. This is what the report would include, letting me know that I was also part of that.
So
yeah, I think we want to know collateral, right? Like if you have information that can track me and I'm not even the target, I kind of want to know, am I being tracked in a way where I'm not actually the target, but you still have this information? I think that's the whole purpose, really, is to make sure that these things aren't overreaching or doing things that cause harm to people's protected privacies, because you might have a reason for one person, but it also catches everybody else's situation in that same moment. So I think that's sort of very specific.
Chair, if I might just jump in here, I think to put an example on what Councilor Arroyo just said, for example, license plate readers are technologies that track cars and the locations of cars at given moments. Mm-hmm. And that's a type of technology that is used by law enforcement both to conduct general surveillance of the public, so where everyone has been driving, and is used in specific criminal investigations to locate particular cars. So that's an example of the kind of information that, you know, we would want disclosed to the council. Like, we use license plate readers in criminal investigations, and, you know, we retained information about all drivers for a year or whatever.
Okay.
Okay, but would you?
I think it's fair.
Would you be looking for, like, information on, you know, just that general information? Not looking for, we got, you know, plate A, plate B, plate
exactly.
Yeah, absolutely. Yes, exactly. Yes, correct. We don't want that. We don't need plate A, plate C. We want the general. So I think the way that Kay described it is perfect. You use these license plate readers, you get all this other additional information, and then what do you do with that additional information? When you terminate it, when you delete it, it's like, that's general without you having to say, so plate A, plate B, plate C, plate 6. Like, we don't need that. Does that make sense, Superintendent?
Yes. I mean, I was in a meeting the other day, and it was explained to me on the license plate readers that, you know, 99.9% of the license plates, that information is never even accessed. Right. It's okay. It's only very, very tiny. You know, we look for, you know, a half an hour. There's 20,000 hours of data there. We look for a half an hour only in all that 20,000 hours. We look at one specific point in time. That's it.
Okay. So I think we're in agreement. So number 2.
So if I might, Counselor, the administration suggested removal of this language here is actually related, I think, to the example that I just gave. Mm-hmm. So, for example, the city's collecting license plate reader data on where everyone is driving, not just people who are suspected of, you know, involvement in criminal activity. What happens to that data, right? Is that information shared with the FBI? Is it shared with ICE? If it is that done on a case-by-case basis, where, for example, ICE will say, we're looking for this one particular car. Do you have any records in your license plate reader database of this particular car? And if so, is that done simply by an email, by a phone call? Is there some, you know, legal standard that the BPD is using to determine whether or not they'll share that piece of data? Or is the entire database of all of those records accessible to ICE and the FBI and, you know, law enforcement from other departments in Massachusetts? So that's the kind of information that we're really hopeful will be disclosed to the council and to the public. And so that's why we would oppose the change that the administration has suggested.
And I would also just add to that one of the things I would hope would also be there is what happens to this collateral, right? Like, how long do you hold the records of my travel on this? Like, is it a year? Is it 2 years? Is it 3 months? Is it 30 days? Do you get rid of it? Does it not save beyond, like, for instance, cameras, obviously, this is a good example because they have tape, right? So cameras refresh every 7 and they just delete everything they had. Like, does this work that way? Those are the kinds of questions I would be looking for specifically myself. Like, and so I don't think that's very specific in that I don't need to know what happened to Councilor Edwards' license plate. I just need to know what's the general practice here.
Okay. All right. That's all good. I mean, it's like ICE. I mean, we wouldn't be providing anything to ICE unless it was a criminal investigation. There'd be no, civil, but by the city ordinance, when we don't cooperate with them, we don't turn anything over to them unless it's a criminal investigation. With all this data and stuff, with the cameras, the license plate readers, there's, the system we have right now is an older system. We're looking at, part of, we're always evaluating things, and they're evaluating a new system. And part of the reasons we're looking at this is because it has a very strong auditing capability to it. You're going to be able to look at it and say who accessed it, when they accessed it, what data was taken out of the system. There'd be a clear accountability for this. And we'd be able to, build that trust there that, no one's playing games with this thing. It's being only used for legitimate purposes.
Okay. So we're going to go on to the next edit, red line. Number 7, an estimate of the total annual cost of the surveillance technology, including personnel and other ongoing costs, and what sources of funding will fund the technology in the coming year, if known. That's to be included in the annual report. Added and suggested is this should include estimated total costs with compliance with the ordinance. I think that's fine. Any concerns?
So I have a concern about that, Chair, which is just that, a properly functioning democracy needs to build in the kinds of accountability and transparency that we're all trying to achieve here. And, for example, this would be akin, in my mind, to the state public records law, requiring that each agency tell the public how much it costs to comply with the public records law every year, which in my view is kind of a measure that sort of flies against transparency and accountability. So, that's my concern here. The ACLU would recommend not including this.
And my concern is I don't know why it would change. I'm assuming you would have to create some mechanism to compile this report that's already in place, that is already whether it's human administration or some kind of database that is already compiling annual surveillance reports in that information. I don't know why for every instance of an additional surveillance system, that would mean we would need to have some brand new total cost for upkeep of whoever's already on staff to document this. I like it. So for instance, instead of documenting 3 or 4 or 5 or 6 or 100 systems, now it's 101. So now there's this brand new estimate, and then it's 102, and now there's this brand new estimate. I don't know why that changes that one person who's already on staff's job in a way that is tangible that way, that you would be tracking on every request a brand new total on what it costs to be in compliance. If it's somebody on staff to do that, then it's that person's salary that already exists to do that. So I don't really know how that would change from surveillance request to surveillance request. I don't know why that would be a moving target for every single one if you just have a staff that's dedicated to doing this compliance.
I understood that they were just being totally transparent with all aspects of cost. I understand the ACLU's concern that it provides a connotation that it costs money to deal with this. And honestly, the reason why it costs money and oftentimes to deal with FOIA requests is because they're not complying with them, to be very frank. And they don't set up a system to be totally transparent. So maybe that would be that the delays or it's taking us so long is because you didn't set up a system to actually respond to the public's request for transparency. I also thought it was a matter of demonstrating simply that what issues or resources or funds are necessary. But if you think the connotation is more, or the stigma is outweighs the transparency for costs, then I'm okay. I'm agnostic about it. This is to the ACI.
Madam Chair, can I, oh, sorry. Can I add something there?
Sure. Yes.
So to Councilor Arroyo's point, I'm imagining the intent of this, and you sort of stating that would it be done for every technology? But I'm imagining the intent is that in the annual surveillance report, that there's some estimation of the cost of compliance, I guess, across the entire program, as a way to be sort of reporting back to City Council about, what it takes to comply with this. Again, not an edit that I made, but could see how that becomes useful in how we sort of structure the budget or plan for that in the future. But I don't imagine this is intended to be for each individual technology, but maybe for the program as a whole.
So I guess, let me try and follow this, right? So you're saying, well, you didn't write this, right? But I guess what you're trying to articulate is that every year we get a bill or sort of an estimate on what the cost for compliance with this particular ordinance is across the spectrum?
I think that would be the thought. And I'm thinking back to maybe a previous working session where our colleagues in Do It had some concerns about what it would mean for their staffing levels, that they need to sort of comply with this. I don't know if that exists in the other departments as well. But yes, across the spectrum, what would it cost?
I guess
I think that's the intent.
The question I would ask is to use the example they brought up earlier, what exactly is the difference between having a total told to us on a compliance with this as to what we just had a whole thing about FOIAs, having our information director do what they do for every single department in the city. Like we don't have I don't get a bill for that every year. I don't get an estimate. I've never adjusted. In all fairness, I've done 2 budgets now. I don't even think I've asked, like, what does this person need? What are their staffing like? I don't even know that that's ever come up. It's a weird wrinkle because I don't know how that would be any different as a transparency sort of foiable public good, public transparency thing than what he does currently or what anybody in the future does in that role. I don't get one that says like the Boston Globe made 50 requests this year and the WGBH made 28 and Ricardo made 7. And so that cost this much more today than it did yesterday.
So just a pointed question to Councilor Arroyo, that you don't find the language to be necessary?
I don't think it's necessary, but I'm sort of like you. I'm sort of agnostic on it, and the fact that you have the advocates opposed to it, and sort of the city doesn't really have a totally great answer for why they should do it. I don't really.
Okay.
It's sort of tipped the other way, but I'm agnostic on it, to be honest. Like it doesn't.
Okay. I think that's okay.
Yeah.
All right. Let's go continue on. I think we're close to getting to the end. So in the next section, based upon information provided in the report, shall determine whether benefits of the impacted city departments and community of the surveillance technology outweigh the financial and operational costs, and whether reasonable safeguards exist to address reasonable concerns regarding privacy, civil liberties, and civil rights impacted by the deployment of the surveillance technology. If the benefits or reasonably anticipated benefits do not outweigh the financial and or operational costs, or civil liberties or civil rights are not reasonably safeguarded, this council may recommend modifications of the surveillance use policy that are designed to address the city council's concerns to the mayor for their consideration. Withdraw authorization for continued use of surveillance technology by a majority vote of the city council, and or request a report back from the mayor regarding the steps taken to address the city council's concerns. The language or the suggested edit is to strike withdraw authorization or continued use of the surveillance technology by a majority vote of the city council. I can guess where.
Yeah, I didn't think they called me.
Yes, I will just go straight to the administration.
Thank you. So again, this would be where that working group would come in. It could, you could send it out to them, and hopefully they come back with some modifications, and then it could be put to a vote again.
See, I like that use of words that you say, because you said the word hopefully. And the problem is what this allows is for me to hope a lot, but have nothing to make sure that they do it. And so that's the problem with this, as far as I see it, is that I'm hoping that the task force addresses my concerns, and then I'm hoping that the mayor cares, and then I'm hoping that it gets put in place. But there's no mechanism for me to say, but if you don't, there's this. I just kind of got to get stuck.
No, then it reverts back. I mean, if you're gonna, you vote to.
Well, it doesn't revert back. It says that it literally.
No, that's, so take out that withdraw, eliminate that, and just put in the language about send it to the working group. Don't withdraw it. You're not going to withdraw it. Just send it to the working group, and then wait, see what they come up with, and then evaluate it, and move on one way or the other.
Might I jump in here, Chair Edwards?
Yeah.
So this is a key part of the ordinance in our view, because we want to make sure that there's ongoing accountability and oversight for everything that the council has authorized, right? And so this is really key, that the council retains the power to withdraw consent, essentially. For example, if the council authorizes the use of technology X for purpose Y, and then somebody reports back to the council, well, we actually haven't been using it for purpose Y. It hasn't actually helped us solve any serious crimes, but advocates have found through public records that the technology was used to monitor, peaceful dissenters, for example. I think that would be a key example of a technology that the council might want to revoke authorization for. It hasn't demonstrated any value in terms of protecting public safety, and it has been used to violate people's civil rights. So, there's no universe in which that's acceptable. So we're going to withdraw consent and say you're not allowed to use this anymore. I think that what we've already agreed to with respect to the surveillance working group makes sense in those contexts, but this section right here really is one of the key pieces of the ordinance. And
Right.
So we would recommend that you just not adopt this change at all.
Okay.
So I think I would like to, if we, before you revoke, there's an opportunity to correct. And then if corrective action isn't taken, then revoke. Maybe you suspend. There's an interim step of suspension. If you find it's that egregious, you suspend it and give us an opportunity to correct it before revoking it. Maybe that's an option.
Chair, so respectfully, that's in the ordinance. So the two other options are for the council to recommend modifications to the policy to address the concerns, and 2, to request a report back from the mayor regarding steps that have been taken to address the council's concerns. So, we're confident that those options are already in there.
Okay.
All right. And then finally, if need be, to withdraw it altogether. Okay. I think we're going to continue on. I don't think the language is going to be, at least that part will be removed. I think it'll be taken as serious as it is written, intended to be written, which is it's a big deal to take away something that the police have been used, and it should be seen that way.
Yeah, I don't think that's a start. I like that there's 3 things there. I don't think it's the starting point. I don't think you jump to, unless it's that egregious, I don't think we jump to revocation. I think there's even an option there just to have them explain it, right? And then possibly do nothing else.
Right. All right, we're going to go to these. Yeah, you can continue on. Thank you so much. I just want to give kudos again, hand clap to Michelle.
Yeah, you're doing great. I've only about 13 times hit the scroll button on my mouse to scroll these, only to realize that I do not control them. So thank you, Michelle, for scrolling this, because I've literally at least 3 times I'm like, can I just scroll a little bit? See, there I go. I'm over here doing it, and you're doing it too. Thank you.
So I think the next section change is again, the 24 months that this section 1663.1 63.3, and 63.5. In the current version says it take effect 9 months after the adoption, and the suggested edit is 24 months for 1663, and shall take, I think, 24 months for the other 63.5. I think we were okay with 18 months for the report back.
So I think what we agreed to was 12 months with an ability to ask for more time.
Oh, okay.
With the ability to request an extension.
Okay. Right, and I would, if I might, Chair, I would just note that you actually have to add up these months together, because the ordinance won't take effect at all until the way that it's been written in the initial draft is 9 months, right? So that would actually be 9 months plus 12 months for the initial surveillance impact reports, unless I'm misreading it. That's my read of it.
So there's a 9-month build-in. So I guess this answers Mr. DePina's issue, which was basically you got a 9 months build-in and then a year on top of that.
To do the surveillance impact reports, right? So it's actually
pretty close to the 24 months already.
Right, exactly. So yeah, we would recommend that we just leave the language the way that it is.
Yeah, 9 in a year. Yeah.
Okay.
That's better. Okay. That's better for their end than the 18 months, frankly, right? So like that works. That should be enough.
Yes, thank you.
Okay, so now 1663.9, establishment of a surveillance data and privacy working group. This is the final edit, the final red light component.
Yeah, this one is Chris's. This is Chris. You did this one. I think the way you explained this was this is so that you can create guidelines and stuff for all the places that we did not make this applicable to. All the other departments. This is for that.
Correct, Counselor. This is something we talked about actually with Kate as well. We're really excited to do this work. We think it's important, and we think it sort of sits outside the ordinance that exists now. But this is about figuring out ways to do transparency, thinking about what the sort of professional development opportunities are for those departments, looking at procurement, coming up with sort of a whole range and process that we can sort of document and then put forth before the mayor and city council to move forward. But we're jazzed to do this. This might not be the final language here. Happy to sort of work through it, but we think this is a really good step that the city should be taking for all those other departments as well.
So the one thing I would say just from Jump Street is, one, I don't really think I would have any real issues with this, and I'd ask Asa if they have any issues, but I think this is a good thing. I think this is what should be appropriately called the working group. I think what has been called the sort of surveillance oversight working group that's been streamed through here as surveillance oversight working group, we should just come up with a name for that, because it's not really a working group. It's going to be some kind of permanent creation. And I don't know if we call it the surveillance oversight, committee, right? Like, I don't know what we call that, but that has to have a different name, because the appropriate use for me for a working group is this, which is something that eventually disbands, right? Like this eventually ends. This other one doesn't. And then we can have that clarity throughout the entire document that these are two different things.
Yeah, Counselor, I would agree. And maybe something like advisory board for the other
advisory committee or board or whatever whatever the legal language is, that's be fine, or commission. I don't know what the thing is, but whatever it is has to be more permanent in terms of its language. We can clean it up so that there's no confusion between this working group does this stuff, what this one says it does, and this other thing is its own sort of created thing. And then it just has to be clear that it's a recommendation advisory board group. But I think that's good, right? That's why I like advisory in the title. So I agree.
Fine. That's good.
All right.
Yeah, that makes sense to us. And just to be clear, the ACLU is very supportive of what the administration has done in this final section.
Yeah, and so am I. I think it's a great call, because this is sort of getting to the root of it, which is really trying to deal with ensuring that even if we're not dictating that they have to come to us, that the city is taking those concerns seriously and saying these are the things that we think we should be doing for best practices. And I really appreciate that they're taking that next step. So thank you on behalf of the administration. And then I think we've reached consensus on most of this. I don't know that there's anything here where I appreciate, frankly, thank you, Superintendent Donovan, for your time and your effort. We don't, I'm gonna just be honest, we don't usually get red lines from BPD. And it is a refreshing change of course to have a conversation that is based on these are why and what we think the language should be, rather than sort of let me try to scare you with this could happen or that could happen, but rather like a very reasoned, well done conversation. So I really do appreciate that, Superintendent Donovan. I know that this took effort and work. And so thank you to you and BPD for your engagement in this. And I want to thank the administration too, because the working group was your idea. So I think the going that extra step is very appreciated.
All right. I want to thank all of you too. So it's appreciated.
And everyone's house is still around. No one's been blown away by the tornado.
Yeah, nobody's gone. So
no. Okay.
Though if they were, we wouldn't really know. I mean, I'd find out not this way, right? Like you're not.
The only noise now is my stomach.
Okay.
Yeah, so thank you, by the way, Madam Chair. I know we went over and you wanted to get this done. You did, so thank you.
Thank you, Madam Chair.
All right. Thank you, Madam Chair.
Thank you very much, everyone.
Thank you, Madam Chair.
Thanks.
Thank
Thanks.
you all for your patience. I know I was late. I want to thank Councilor Wu and Councilor Arroyo for handling this and getting it done. I'm proud of the work we did. There's 22 pages of work and edits twice through. I'm going to try and implement a lot of the compromises and change in language. We committed to that. We get that work done. So that means additional meetings with the advocates, additional meetings with the superintendent and with BPS to make sure that the language is getting to a certain point. Then I look forward to a more efficient working session where we're just dealing with the edits, not the overall conversation, and just bam, just we've agreed to this language, we've agreed to this language, to present that to the public and to get a final draft done this year. All right. Thank you all so much. Thank you.
Thank you.
Thanks, Councilor Arroyo.
Thank you.
Thank you as well. Is it Chief Dupina? What is your actual
Call me
title?
Sam. Call me Sam.
All right. Well, thank you, because I think it was good for us to have a conversation. I know that you guys have good intentions. My issue is sometimes the intentions of what, like this is what we run into all the time. There's good reasons, there's good intentions behind why I want to document this, but then somebody else, some other organization says, great, you documented that for me. Now I can use that the way I want to use it. And that's not in your control. And that's what I've always tried to avoid.
Appreciate that.
So thank you.
Thank you likewise. Bye-bye.
Thank you.